You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Smith versus the state of Florida.
May it please the court. For the record, my name is Martin McLean. I'm here today representing Derek Tyrone Smith.
You all, if you could speak up.
I always forget that, don't I? First, I would just want to advise the court that the 11th Circuit held oral argument on February 3rd. It was in Montgomery, Alabama, and we appeared before the 11th Circuit. There were questions about this appeal, and Judge Carnes actually said he couldn't imagine the 11th Circuit going ahead and deciding their appeal until hearing from this court about the bullet-lead evidence.
And I can't imagine us deciding this without them telling us how we screwed up Brady.
And on February 4th, the next day, they issued a memorandum indicating that they were withholding a decision in the case until this court had decided the bullet lead issue.
Just on the bullet lead issue.
Yeah, I mean, they want to know, because they don't view that as a federal question, because it's a state law evidentiary question.
Let's get to the lead question.
Yes.
I'm struggling, having trouble with how it could be a Brady and Giglio issue.
It's not alleged as a Brady and Giglio issue.
Okay, well, it has been discussed, so I want to make sure that.
And that's one of the claims of error as to the circuit court's ruling, because it treated it as a Brady Giglio as opposed to a newly discovered evidence under
So you
Jones.
agree that these letters, I mean, certainly the
Correct.
government didn't have them, didn't?
Correct.
Okay.
This is under Jones v. State,
Yeah.
591 Southern 2nd 911.
Now,
I'm familiar with it.
Okay.
What, this was, the CBLA issue has been developing for several years, starting with, I guess, the 2004 report.
Yes.
When did you first file this claim?
Well, what had happened is when the 3850 was filed in, I think it was 2000 or 2001, an ineffective assistance of counsel claim was filed that alleged that the trial attorney in 1990 had failed to investigate this issue, develop it, contact expert. There was an evidentiary hearing in 2002 where Dr. Randish testified for Mr. Smith, saying that this was junk science. And Agent Peters from the FBI testified, and the FBI stood behind Havikos' testimony. That was in 2002. To some extent, I think it's as a result, Randish appeared here and in other cases, and in 2004 is when the FBI decided they needed to look into this further. 2005 is when it's announced the FBI will no longer do it in the future, and it's not until
At that point, in 2005, didn't you know, or didn't counsel know, what counsel needed to know to bring the claim that was brought years later?
Well, actually, in 2005, I was still pending in this court with the ineffective assistance of counsel claim. And the FBI at that point in time was standing by their prior testimony. They were simply saying, henceforth, we're not going to do it anymore. But it wasn't until 2007, and sort of the announcement happens with the 60 Minutes show, that they say, well, yeah, not only are we not going to do it anymore, we're now going to look into the testimony that was presented in the past. And so what happened is I had seen the 60 Minutes show, the Innocence Project was involved, I got in touch with them, sent them all of the records in the Derek Smith case that I had concerning Agent Havikos' testimony. Innocence Project provided it to the Justice Department, and then they issue a letter in May of 2008, which is the first time they specifically address Mr. Smith's case and indicate they're not standing by Havikos' testimony anymore. So it's not really until that letter in May of 2008 that we have specific information from the FBI that they're not standing by Havikos' testimony.
But prior to that, you had specific information that they did not believe that this analysis could lead to the level of certainty in the identification of the source of a bullet.
Well,
that was the level of certainty that had been testified to by the witness in this case. Isn't that correct?
I don't think technically that's correct.
Well, if it's not technically correct, why might it be otherwise correct?
Well, let me explain. Because what had happened is we had the 2002 hearing where we have Peters and we have Randish, and the judge who presides says, this is just a battle of experts. They just have different opinions. Then we have the FBI doing additional stuff, and in 2005 is when or maybe it's 2006, but 2005 I think, is when they say they're not doing it anymore. But they specifically say they're still standing by their testimony. They're not abandoning it. And at this point in time, we've not had an evidentiary hearing to actually have somebody from the FBI to explain that. My reading of what their announcement was is simply, we're not going to do it anymore. We still stand by the testimony we gave. But there's not been an evidentiary development on that. And it's not until the letter in 2008 that we have something specific where they specifically review Havikos' testimony.
It seems like to me that at that point, there was information that was available to counsel which called all this into question, and that to be timely, you had to, that started the clock running. Because obviously what happened in 2005 was of some significance.
I thought so, and I notified this court.
What did you, in notifying the court, what did you,
I
did you ask for relinquishment?
believe that at every step of the way, I was filing things, attaching notice of supplemental authority, what's happening. The state's position always was newspaper articles aren't evidence. I didn't have anything beyond that, beyond the reporting. And so I kept trying to advise everybody of these developments.
So you didn't, I mean, the question would be, if when in good, since you were representing Mrs. Smith throughout, did you not feel that in good faith that you could file a separate motion for new trial on the report, or just try to be, and then the related question is, did the judge hold an evidentiary hearing on whether you exercised due diligence?
No, an evidentiary hearing's not been held. And let me technically correct myself. This court's opinion came out March 9th, 2006. Motion for rehearing was done, and so jurisdiction was not in the circuit court at that point in time. It was in this court. And I know that because of the one-year federal clock, I had to file the federal habeas a certain time after this. I don't remember when the rehearing was denied specifically. I filed the federal habeas and filed the 3850 at the same time. In the 3850, that was before the 60-minute story, I included the claim based on what I had, which was simply the announcement that they weren't doing it anymore. The state responded saying, that doesn't mean anything. The judge ruled, that doesn't mean anything. And in fact, there's an order denying the 3850 with the claim pled on the basis of simply the FBI is not doing this test anymore. That's entered November, I think it's November 7th of 2007. We were at a status, we showed up for the status, the judge announces this ruling. At that point in time, I was surprised. I asked for 30 days because I needed some time, other stuff was going on, to do a rehearing. And it's in that 30-day period, while I'm working on the rehearing, that the 60-minute story happens. And so I have pled prior to the 60-minute story, what Your Honor has asked about, the FBI is not doing the testing anymore. The state said, that doesn't mean anything. The judge ruled that doesn't mean anything. And then the 60-minute story happens. I then, on, I think it's December 4th of 2007, plead the 60 minutes and ask for the opportunity to amend the 3850 to include this information. Ultimately, the judge grants me the opportunity to amend, and the amendment is due at the end of May. And I get copies of these letters that are issued by the FBI, I think it's May 27th, 28th of 2008, and include them in the 3850 that's filed at the end of May of 2008. So, I mean, at every step of the way, I was trying to bring this issue up, and the state had maintained just a difference of experts until the letter actually showed up from the FBI, and those are...
Let's just, since you have limited time, let's, you didn't have an evidentiary hearing in this case on the bullet analysis, but if you're bringing it as a motion for new trial under Jones, the standard is a higher standard than Brady and certainly Giglio, which is a probability of an acquittal. And is that correct?
Normally, except this court in Mordenti indicated when you've got both a Brady claim and a newly discovered evidence claim, you use the Brady standard.
Well, let's go in though on just on the newly discovered evidence.
Yes.
So the judge, if we were to send this back for an evidentiary hearing, first the question would be to evaluate the nature of this evidence, and then what you're saying is the second step would be what would the judge evaluate regarding which Brady claims are you talking about? And really for this court and for me, give me your three strongest Brady claims that you think would need to be looked at cumulatively.
Well, first, let me address in terms of sending it back for an evidentiary hearing. We are in an unusual posture in terms of the newly discovered evidence because we have these letters. My contention is these letters establish the evidence doesn't meet the Frye test. Habekost's testimony would not be admissible. This isn't a situation where it's new evidence that would be admissible and it wouldn't change.
Let's go back to the standard. I mean, we understand that. So how about going to the, really the prejudicial aspect?
So the prejudicial aspect requires then looking at this case with Habekost's testimony struck out. And not just looking at the trial, but also looking at what happened when this court was considering the Brady claim and the ineffective assistance of counsel claim. So, I mean, at every step of the way, the state and the courts have relied upon this have-a-cause testimony, first in affirming the conviction, and then in denying the Brady claim, because this was significant evidence. Because the Brady material goes to impeach all of the other witnesses. This is the only thing that wasn't impeached by any of the Brady. Turning then to the Brady, there's Derek Johnson and Derek Johnson's meeting with Melvin Jones, which had not been disclosed. There's Melvin Jones calling the prosecutor prior to the second trial and advising the prosecutor that he was afraid he was going to be charged with sexual assault because his stepdaughter, 16-year-old stepdaughter.
All right, now how is this is where this chessboard situation concerns me. We had held that the fact of Jones being concerned about being charged was not Brady, the court.
Yes.
I don't know if we meet with.
Yes.
The 11th Circuit said, no, we were wrong. That was Brady.
Yes.
They then sent it back to the trial court to evaluate all of this Brady evidence.
Yes.
And that's now pending before the 11th Circuit.
Yes.
They're going to wait for us.
Yes.
But if we don't really, in terms of the law of our case, we wouldn't be considering that as Brady. So in terms of not getting you in a whipsaw situation, would it be, I mean, would the best be to say that this is, as newly discovered evidence, should be remanded for an evidentiary hearing, but that the trial court should wait until the 11th Circuit rules? I mean, because otherwise we're going to be, this is never, I don't recall a situation where these parallel tracks have been occurring. Or should we look at what has already been said by the 11th Circuit and make our own determination now whether as to what should be looked at in a cumulative analysis?
I can tell you, I mean, first of all, if it helps, what I think the 11th Circuit's point of view is in deciding whether reasonable probability of a different outcome under Brady, they need to know, was have-a-cause testimony, is that under state law outcome? Because to the extent that that would affect how they view the reasonable probability of
Well, we can't decide in this appeal whether the testimony would be admissible. I mean, we'd only, what we'd say is it's newly discovered evidence that certainly it would undermine his testimony significantly, but as to whether it's subject, are you saying that we now should be deciding whether it should have been Fry tested back then when that issue wasn't even raised?
Well, I think that this court, I mean, my position is this court could say this new information from the FBI means it doesn't meet the Fry test. And this is newly discovered evidence that shows this was not admissible. I think this court could do that.
Okay,
but I also understand this court could say, we're not prepared to go that far. We want an evidentiary hearing first.
So, but as far as, so this doesn't go into the next decade, you think that you mentioned that the issue with Melvin Jones is Brady.
Yes.
That are all the Jones information, and he was a witness, an eyewitness to murder that was he was relied on.
He claimed to be, yes. There's Brady as to Melvin Jones, Derek Johnson, and Magruder, who is the person who worked at the Hogwarts.
And none of this goes, does any of this go to the guilt phase, or does this all go to the penalty?
It all goes to the guilt phase, Your Honor.
Well, but what says he's not that he wasn't involved in the shooting, as opposed to just maybe not the shooter?
His defense was innocence, Your Honor, that he wasn't involved. It was only Derek Johnson who, the question was, what was the degree of his involvement?
You have Johnson, and then, but you have other, you would agree, there's other evidence of him having the same gun later that day.
The gun was never found, Your Honor.
But I thought the Canadian tourists.
Right. There was a gun that the Canadian tourists saw, but that gun was never found. And so all we're relying upon are Derek Johnson, Melvin Jones' identification or the description of a gun. And so that's why the bullet lead testimony becomes so important, because there is no gun. And it is, the bullet lead is what provides the link between the victim, the bullet fragment next to the victim, and Derek Smith's uncle.
Now,
and so,
in sending all of that, though, is past Brady. Is there anything else in this case now that the 11th Circuit hasn't considered as being Brady?
Priscilla Walker. There is some aspect of Priscilla Walker that is before the 11th Circuit, but the important aspect, which was included in this 3850, is when I was preparing the federal habeas, I discovered that she was Patricia Suggs. She was in jail under the name Patricia Suggs at the time she testifies in 1990. They change her into street clothes, bring her in, do not disclose that she's in jail on a probation revocation. The defense doesn't know that. And that she's arrested on May 4th. She appears in court May 8th, enters a not guilty plea. May 10th, she testifies against Smith under a different name. And May 11th, she bonds out of jail.
But didn't in the public records you received, wasn't that all that? Wasn't
No.
there information there that would have
What was there?
let you know that you needed to be looking into that?
And we did look into it. And what was there were 4 names that one of those 4 names was using other names as aliases. The information on Patricia Suggs had a different date of birth than Priscilla Walker. It had a different social security number. We didn't know if there was a real Patricia Suggs. She's using the false name of Priscilla Walker. She's not our same witness. We didn't know. All we knew is that there are these 4 names. So what we do is we go and talk to Priscilla Walker. She tells us, I'm not Patricia Suggs. I never had a welfare fraud case. What are we supposed to do? So we had those names, we look into it, and it's not until I discover in 2006, when preparing federal habeas, that in 1992, Priscilla Walker had a sentencing, and they were trying to figure out the score sheet on the sentencing guidelines, and they did a fingerprint analysis of the Patricia Suggs case and said it's the same person. So it's not until we have that notation. And I'm relying on banks from the U.S. Supreme Court. When the state hides information like this, they can't just sort of drop breadcrumbs and say, oh, you're supposed to figure it out. They have an obligation to come forward and say, hey, she was in jail.
Is that a Giglio violation, or?
Yes, I believe it is, Your Honor. And so that's what's also in the current 3850 before this court.
That has not gone to an evidentiary hearing.
That's correct. That's not gone to an evidentiary hearing. And the 11th Circuit, in their opinion, said that's not been exhausted in state court, so we're not going to consider that.
You're now down to 2 minutes. We've helped you so much in using up your time. I'll give you an additional couple minutes.
Okay. Thank you, Your Honor.
As well.
May it please this honorable court. Your Honor, my name is Catherine Blanco with the Attorney General's Office. At the outset, I'd like to make one brief comment before I begin my argument, and that is that accusations have been made in opposing counsel's reply brief alleging dishonesty on my part with respect to my answer brief. I vehemently deny the accusations. I stand by my answer brief. My arguments were predicated on the opinions that were issued and the orders issued by the District Court and by the 11th Circuit. Now moving on to my argument, Your Honors. This is a successive post-conviction motion involving comparative bullet-lead analysis testimony. It is misleading to say that there was no evidentiary hearing ever on bullet-lead analysis testimony, because indeed there was.
That was the one, though, when the FBI was standing by the agent's testimony and they didn't disown what, I mean, it's a dramatic change, and we have to give the FBI credit for coming forth and not trying to continue to stonewall, but they not only decided they're not going to use it anymore, but they committed to go back in every case and make specific findings. So the 2002 evidentiary hearing that we relied on in affirming this conviction had testimony that the FBI at that point, it was their position, but it's dramatically changed now.
What their position is, Your Honor, is set out in their letter. And it says, and the letters are very specific, and we have, and there are a total of 3 letters. There are letters that were issued on May 27th and May 28th, 2008. There was a 3rd letter that was issued in January of 2009. The letters, in the FBI letters, and Your Honor, I'm briefly reading because I don't want to misspeak, from the January 12, 2009 letter that is in, all 3 letters are in the file, and we have cited them in our answer brief as well. And the FBI states in their January letter, referring to the May 27th and 28th, 2008 letters, in those letters, the FBI concluded that the testimony provided by the FBI laboratory examiner, Donald Havacost, at the 1990 trial overstated the significance of the examinations conducted, possibly leading the jury to believe the results were more meaningful than they were. Additionally, it was the opinion of the Federal Bureau of Investigation Laboratory that the testimony provided by FBI Laboratory Examiner Charles Peters in the 2002 post-conviction proceedings conformed with the appropriate standards. Since issuing these letters, the FBI has been asked by the Innocence Project to clarify its assessment of Mr. Peters' testimony. Your Honor, there's only one more paragraph, if I may, to make sure that I do not misspeak. The FBI's opinion that Mr. Peters' testimony was appropriate was based on the specific questions asked by the court regarding whether, based on the scientific data available during the appellate proceedings, it was Mr. Peters' opinion that Mr. Havacost misled the jury or exaggerated the relevance of FBI-led composition analysis. At that time, which was 2 years before the results of the National Research Council review of the CBLA techniques were published, Mr. Peters' testimony would have in fact been appropriate. Applying today's standard of review, and to the extent that the appellate testimony of Mr. Peters is now proffered to demonstrate the appropriateness of Mr. Havacost's testimony during the trial proceedings, the FBI repeats that the testimony of Mr. Havacost was inappropriate for the reasons previously stated. In other words, Mr. Havacost, at the time of trial, the FBI, by virtue of these letters, has announced that he overstated the significance. In other words, drawing the definitive link. The NRC report, when that was issued...
What did you say? What was the last thing that you just said?
In other words, overstating the link. For example, you still have the ICP testimony.
Essentially, he said it couldn't be a coincidence.
That there...
match.
In light of the 10-year span between the purchase of the bullets, which was 1973, or 1972 or 73, and finding the composition. Now, by the match, they're talking about the proportions of the elements. Not that you have 5 elements and say, okay, these 5 elements are what make the match. What would make the match would be the proportions that you have. And so the odds of finding those, and the testimony was not actually to the box, linking the box, it was linking to a common source. Indeed, and we've cited in our brief, Agent Havacost said, sure, you're gonna get boxes with similar bullets, with different bullets, but what happens when you have this lead fragment that is matched to bullets that were purchased 10 years earlier, the chances become more and more remote. So it's essentially overstating the significance of the chances of finding an unshot box of bullets or an unshot box of bullets with that common source. Now, Agent Asbury testified similarly. He testified to the composition results from the neutron activation analysis. That testimony has never been challenged, and he testified at the same hearing, at the same trial in 1990, as to the match of 3. And again, he explained by match, this is what I mean by match, and said that it was consistent with. Now, the identification of the comparative, the lead, the comparative bullet lead analysis is not what identified Smith as the shooter. As a matter of fact, in closing argument, defense counsel argued, and I'm reading from the closing argument, volume 8 of this court's record in case 76491, record page 1326, and this is defense counsel speaking, talking about the witnesses. And it says...
just before you go into that,
sure.
Are you, at this point, since this was denied without an evidentiary hearing this time, are you going to the prejudice or the new prong when you're talking about
well,
this?
the likelihood of acquittal on the Jones.
What do you say, though, about what, and I don't, did you argue in front of the 11th Circuit?
I did.
Okay. They're waiting for us to say whether this counts as newly discovered evidence.
Correct.
Before they can then look at all these other areas that they think are Brady. Then we've got a possibility of this Priscilla Walker issue. How, based on our case law, can we, I might agree with you that if all we were looking at right now, with nothing else before or pending, that if you just took if you just take that analysis and take Jones, they're not going to meet the standard of a probability of an acquittal based on this. But what I'm hearing, could you address how really either this court or the trial court should appropriately analyze the cumulative nature of what's been discovered?
Your Honor, with respect to what's newly discovered, the defense has relied on mordente to say, okay, if you are considering newly discovered and a Brady claim that are both raised. Mr. McLean has represented this morning that he's not raising a Brady claim, he's raising a straight-up Jones claim. So when we are looking at this particular case, what we have before us is the trial court's ruling on a successive Rule 3.85 motion raising the CBLA testimony and to a lesser extent, certainly there was an allegation with respect to Priscilla Walker that's been found both by the 11th Circuit to be procedurally barred and by the trial court to be procedurally barred.
If the Priscilla Walker is a Brady claim, how Brady doesn't have there may be other issues. It's equally available to both sides. I mean, that would be but as far as actually due diligence prong of Brady, what I'm hearing Mr. McLean say is that when the state put on this witness was actually in jail on charges and for violation of probation. Is that correct?
The allegation is that Priscilla Walker has an alias of Patricia Suggs. The state's response, this was raised early on in the prior 3851 with respect to a Priscilla Walker claim. And the state's public records disclosures in the prior case provided the alias information. Obviously, I personally don't know if Priscilla Walker is Patricia Suggs. I understand Mr. McLean's representations. I obviously understand the arguments that he has made before. But the finding was that is procedurally barred. You have a due diligence prong to have used that information. You had it back at least in 2000, as the trial court finds.
What
you
if
had
the
it in
information
2001.
given is, what if the information given shows facially they're not the same people, different social security numbers, different dates of birth, and it shows facially these aren't the same people?
Your Honor, I cannot tell you anything other than what the records were provided. They provided an alias by that name.
That's not
as
what I
far
asked.
as
Excuse me, that's not what I asked.
Okay.
If the state gives defense counsel information that facially shows that these two people are not the same person, and we can look at dates of birth, we can look at everything on there, but then later something develops and it demonstrates, oh yes, they were. How do we deal with that? I mean, does the state can just walk away from that when they are pulling someone out of a jail cell? I don't know if this is true or not because there's no hearing on it. But if that's the case, why is his argument incorrect?
I think his argument is incorrect, Your Honor, because the allegation is that somehow the state was withholding information and he could not have discovered it earlier.
Well, just what I just asked.
The trial court,
how can you discover? I mean, if in fact these are the true facts, witness is in jail under a different name, dress her up, bring her into the courtroom, never disclose it. What we do disclose is incorrect information, never connects the two, does not connect the two. Dates of birth, all these things are different. How do we look at that? Are you saying the state satisfies its burden if it gives information that's incorrect, yet pulls somebody out of a jail cell to testify and never discloses?
Your Honor, actually I'm saying the converse of that. The information the state gave was not incorrect. The state gave all the information it had as to the... Am I correct? There's not been an evidentiary hearing. These are allegations. I agree with you. We don't know for sure, but those are the allegations. And that was a claim that was... allegations regarding Priscilla Walker were alleged in the initial post-conviction proceeding and were not pursued. There were claims that were summarily denied. The trial court... I'm sorry, I understood that they found out about her being pulled out of a jail cell much later.
Am I wrong on that? Or at least the allegations?
Those are Mr. McLean's allegations.
Well, that's
what we are relying on are the face of the documents that were provided to the defense and the face of the trial court's
But
order.
you see, the problem we have is this is somewhat a jigsaw puzzle. And it is sort of always interesting how somehow Mr. McLean either gets these cases or is able to pull all of this together. But in doing that, and without, the record right now are these allegations, but what I'm concerned about, and what I hear Justice Lewis saying, is that there is right now a potential claim that as to Priscilla Walker, that the state, and through its agents, took her out of jail to testify. Now, it may be that's not the case. It may be. But somebody's got to evaluate that. And he's telling me, and we can look at this, that the 11th Circuit said as to that particular claim of whether Patricia Walker was in jail, that's still a state court claim. And you're looking like I thought I heard him say that. So we go back to this thing. If we feel that the CBLA evidence hasn't been evaluated by the trial court as newly discovered evidence claim, but that there are other claims of Brady that the 11th Circuit has already said were Brady, such as the Melvin Jones issues, which are significant. I mean, he was an eyewitness and said it was Mr. Smith that was the shooter and involved in this case. How do you say that the trial court shouldn't be doing a cumulative analysis of all of this Brady newly discovered evidence claim and maybe Giglio?
Because, Your Honor, when you have a valid procedural bar that should be enforced, and the 11th Circuit, in their opinion on remand, even made that point of addressing Brady claims, and they say we will not consider claims that are procedurally barred.
Which Brady claims did they say were procedurally barred? Because I, again, always understood that if the state has favorable information that's exculpatory, that unlike the other, bringing ineffective assistance claims or bringing newly discovered evidence claims, that Brady imposes the obligation on the state. They can't say, well, you should have found it out. It is up to the state to make sure that the accurate information and exculpatory information is being provided to the defendant.
When you are discussing Brady, certainly, Your Honor, the state has an obligation not to suppress information that is impeachment or exculpatory. And then it becomes a materiality analysis of what constitutes Brady. Where information is equally accessible to the defense, it does not qualify as evidence which is suppressed under Brady.
And then I would agree that that's not really procedural bar, then that's equally available. And so we have a case where somebody says they should have disclosed that they failed a lie detector test. Well, they either know they did or didn't, or they know their medical history. So there are some things that's peculiarly in the information of the defendant. But here, are you saying that Priscilla Walker, it's clear that that was equally available, that the state didn't have superior information, that she was pulled out of jail to testify, if that's the allegation?
With respect to the allegation of her being pulled out of jail, that's an allegation that Mr. McLean has made in successive post-conviction motion. The trial court made a finding that with respect to the information identifying an alias or various aliases for someone by the name of Patricia Walker, that was information that was available on the public record. That was information that was disclosed in the prior post-conviction proceedings, and that was information that is procedurally barred in the successive proceeding.
Are you telling me that if a state puts somebody on the stand, because we sanctioned a lawyer that put on somebody and actually used a false name, that the state puts on somebody that is actually known by somebody else in the trial, not afterwards, that they don't have a duty to find out the correct identity of the person they're putting on at the time that they put that witness on the stand?
Your Honor, I don't believe there's been any allegation that this individual did not testify under their true name. I don't recall that being any allegation that this witness testified under a false name. That a witness may have had other charges under other names, I believe is the allegation. And you may want to ask Mr. McLean on rebuttal to clarify that, but it's my understanding that they have never alleged that Priscilla Walker is not Priscilla Walker who testified as Priscilla Walker.
Let me ask you this question. Are you representing to the court that a trial judge has already looked at this information about this witness being removed from the jail to come and testify, and has factored that into any analysis before? Are you representing?
No, Your Honor.
Okay, so that's
I'm
out.
not.
Okay, all right. Thank you.
There's been no factual determination
Right.
about any
Not
of
as
that.
to
Okay.
that. No, Your Honor.
Okay.
Thank you. With respect to if I may get back to linking Derek Tyrone Smith as the shooter, I was going to just briefly direct the court's attention to the closing argument that was presented at the retrial. And this is defense counsel talking about the fingerprint expert, the FBI guys. It says, but what do they tell you? Again, at line 13, or page 1326. They don't tell you who shot Jeffrey Songer. They don't know. They simply don't know. And so, how do we get the testimony as who shot Jeffrey Songer? And you get it from 4 pieces of direct evidence. You get it from the co-defendant's testimony, Johnson. You get it from Melvin Jones. You get it from the admissions to Priscilla Walker. You get it from the admissions to James Matthews. So you get it from his separate admissions. You also get independent witnesses circumstantially placing the gun in the hands.
The 4 witnesses, though, Mr. McLean is able, and I haven't done the chart here, shown that there are issues potentially as to each of those witnesses. Those are Melvin Jones, who is actually apparently met Johnson in jail. There's something about that he was concerned about the sexual abuse. The listing of Jones as a possible suspect. So we got that. Now we got the Priscilla Walker and the question about her. Johnson's the co-defendant. I mean, obviously anything he's told other people. I told Larry Martin that Smith didn't shoot the cab driver. So this this strong case that you're saying there was, that these were, doesn't really matter what the CBLA was. There's all these other witnesses. He's calling into question these other witnesses.
Certainly he's calling into question the other witness, except I don't believe he's called into question Matthews at all. But you also have, in addition to the direct evidence, and yes, have these witnesses been impeached? Yes. Does that mean we throw out their testimony entirely? No, it means you take a look at the evidence that has been used to challenge them. But you also have the witnesses before, during, and after the murder placing the only one with that similarly described blued black handgun in the possession of the defendant, Derek Tyrone Smith. And you do have still Mr. Cohn saying that it matched the description, other witnesses describing it as Mr. Cohn matched the description. And so as to the defendant's claim, and I see that I've run out of time.
You can take another minute.
Thank you very much, Your Honor. I appreciate it. The state would argue still that the evidence that was presented as to the comparative bullet lead, the testing of those, the quantifiable samples, would still be admissible. The only thing you would find right now is, okay, the definiteness of the conclusion that the FBI would say, that conclusion that matching the common source. And actually in post-conviction, Dr. Randich, who was the defense expert, testified, well, there are these huge melt pours that could take 8 hours to pour the bullets that, from the billets, and so you could have so different bullets matching. And so really his testimony probably helped the state more than anything, because you say, okay, if you have all different sorts of compositions of bullets, here you find a lead fragment that matches 2 bullets that were purchased in 1972. So his testimony actually would, and the defense testimony of Dr. Randich in post-conviction, would actually strengthen the state's argument. Thank you, Your Honors.
Dr. Randish would not help the state at all. In fact, his testimony was, this is junk science. It shouldn't be considered. As to Asbury's testimony, the claim is that Asbury didn't reach the conclusion. All he did was say he did the test. There's a difference between looking at bullet and determining the elemental analysis and testifying as to an opinion as to the match. That came from Habekost, and I submit the testimony of everybody else who was involved would be struck because it's not relevant. It only becomes relevant if Habekost's testimony stands, and it doesn't. It doesn't meet Fry.
Now, the state tells us, okay, so what? We still have direct evidence, it's sufficient evidence that as to what happened here with the witnesses, and there are those who, this is what the evidence is, and this is not going to make a difference.
The problem is, I mean, to some extent, this gets to the argument that was just made that this is, I'm saying this is a straight-up newly discovered evidence claim. No, I'm saying there has to be I mean, I didn't want to come here piecemeal.
I think she said that even if you look at it, look at all these other witnesses, and this is where the evidence is. That's the argument of the state. Please respond to that one.
And that each of the individuals on which the state realized there was undisclosed Brady material as to.
All of them?
All of them. And even Matthews. Matthews was the live-in boyfriend of Walker. And so to the extent that Walker's called into question, Matthews is called into question. And Matthews doesn't testify to what Walker testifies to. His memory is very vague, he's very weak, and he's not mentioned in the closing arguments. And I think that the best place to look to see what is the state's contentions and what are they relying on is look at the state's closing arguments, the initial closing and the rebuttal. And I submit when you look there, you see how these pieces fit together, and a new trial is required, at the very least, an evidentiary hearing. Thank you.
All right. We thank you both for your arguments. The next case on our docket today is Ballard versus the state of Florida.
May it please the court, I'm Steve Bolison from the Public Defender's Office in Bartow. I represent the appellant Roy Ballard. The charged crime for which Ballard was on trial was first-degree murder, and it was a circumstantial evidence case. State had to prove that Autumn Trout was dead. This is a case where no body was found.
Well, there was also a confession to a co-inmate in the jail. Isn't that correct?
If that's giving credibility, there was a jailhouse snitch who was the
But that's
state's
not
last
circumstantial
witness.
evidence.
That's correct. That's correct. I mean, this is not a sufficiency case. I did not argue. I understand the court has to reach the issue of sufficiency, but I did not argue that. The state had to prove that Autumn Trout was dead, that she was murdered, and that she was murdered by Roy Ballard. Unfortunately, due to the way the prosecutor chose to try this case and the trial judge's rulings, the case devolved into a diversionary trial within a trial.
Let me ask you this before you go too much further. Yeah. Did the state have to prove that prior to the admission of the statement allegedly made by Mr. Ballard? Did the state have to prove those elements first?
The state had to prove that a murder occurred. They had to prove corpus delicti. Okay. Now, for corpus delicti, of course, you don't need legally sufficient evidence. You just need some independent evidence. And again, that's not what we're challenging here.
You're not challenging the corpus delicti?
No.
Okay.
What we're challenging on the guilt phase is one issue and one issue only, although it's three separate grounds why what occurred deprived Ballard of a fair trial. It all has to do with the credibility case involving the allegations of child molestation involving Sonny Hotland.
Now, is your argument, because I have Sexton in front of me, right. Is your argument that none of it should have come in or that too much of it came in?
Your Honor, both of those.
Okay, but on the some of it should have come in. We use different words about give the complete picture, and I've been, some of those I've been concerned about. But here, to explain the motive for why Mr. Ballard would murder this victim, it is relevant, undeniably, in my view, that he had a sexually inappropriate relationship with the daughter, and certainly the whole history of that your defense might be no, all he did was have this best interest of his daughter in mind, that he was concerned that the stepdaughter wasn't going to give her the right education. So to give the right picture, at least some of this evidence has to come in. So give me why none of it should have come in, but then if it should, why too much of it came in.
Okay, why none of it should have come in is the threshold requirement for admissibility that the state has to prove by clear and convincing evidence that the collateral crime occurred and that it was committed by the defendant.
Now, is that a threshold requirement for the where it comes in to show motive?
I believe it is, yeah.
I mean, I haven't ever, because I thought that was a Williams rule. This isn't Williams rule. This isn't similar crimes. That requirement, that is, that it might have occurred, isn't really, when it comes to motive, I've not seen a case that talks about that clear and convincing.
Well, what I would have to say on that, first of all, maybe this should be that case. But early on, the prosecutor and the judge were discussing whether or not this was 404 or 402. The prosecutor thought it was 404, the judge thought it might be 402, but the prosecutor was in complete agreement that either way, the state had to prove by clear and convincing evidence that the crime occurred and that Ballard did it.
But what the prosecutor thought about that doesn't determine what the law is.
I understand, but there's an additional reason why the law should apply in that situation, which is that we're talking about probative value and prejudice. Well, if Ballard didn't do the collateral crime, then it not only has no probative value, it has negative probative value.
But we have the sex toy and the DNA in the trunk of this defendant's vehicle.
Right, and we have inconsistency.
So we just ignore that?
No, consider that along with everything else.
Well, I mean, the other things that had been direct evidence from the neighbors, the kinds of things that were directly observed. I mean, eyewitness as to what was I guess inappropriate, but I mean, it's, you know what I'm saying.
I understand that,
yeah.
But at the same time, okay, look at the, I'm going to cite Acevedo, Adano, Alsfeld, Slomowitz, a whole line of cases that I've cited that say that the trial can't turn into a credibility contest on the collateral issue, that if there, if the I want to say Adano and Alsfeld cases, they say it didn't meet the standard because there were inconsistent statements. Here there were not only inconsistent statements, there were inconsistent statements under oath.
Well, it seems to me that what we have here really is neighbors who observe things. We have the victim herself who makes statements about the defendant. We have the sex toy, as Justice Lewis pointed out. I really am at a loss here as to why in the world this was not relevant to this whole situation.
Well, Sonny testified under oath, or so she made statements under oath that no sexual contact occurred between herself and her step-grandfather, Roy Ballard. She made statements under oath later on when she was saying that sexual contact did occur between her and Ballard, that it occurred about every week for nearly the entire 2.5 year period she lived with the Ballards. Now, in the fall of 2005, when she'd already been living there nearly 2 years, DCF was called in because she had told her grandmother, after her grandmother confronted her with some inappropriate behavior that she was displaying, talking to older men on the internet, not having any friends in her neighborhood, her manipulative behavior. She eventually told her grandmother, Kathy, that she had had sex with her current stepfather, John Trout. She had had ongoing sexual relationships with her former stepfather, her first stepfather, Scott Niles, who was later killed in an auto accident. Jackson, beginning
how
when she
does
was
that
5.
negate the fact that she had at least inappropriate conduct with this defendant?
Well, why would she not? In 2005, when DCF was called in, and when she's making allegations that she had been molested by Scott Niles, Bruce Niles, both repeatedly, John Traub, all three involving, full-out sexual contact, and also inappropriate behavior with Guyton Niles, a fourth man. If ongoing sexual relations were occurring with her step-grandfather, who she was living with at the time, why would she have not told her grandmother? Why would she have not told DCF?
Well, but those are all, obviously, that goes to her credibility in impeaching her, and I assume that was done. The issue, though, for the relevancy with the other whether this was reliable enough to come in, it seems to me that there would even have been enough in this case to have separately charged him with sexual abuse, and he could have been convicted based on her testimony, what was found in the trunk, the neighbor's testimony. So I've had concerns in other cases as to whether there's clear and convincing evidence, but it seems to me the threshold's been met. But we'll assume your argument is it hasn't been met, but could you then go on to, let's assume it has been met and it applies. What is your reason the second reason it doesn't come in?
Well, the second reason and the second reason is 9403, that the prejudice greatly outweighs whatever limited probative value it had. And the third reason is it became a feature of the case, not merely an incident.
Well, the second one in Sexton, what could be, the fact that this defendant fathered two of the children and was involved. There was some pretty, what would be very prejudicial information. But we look at if it's the motive, if that's what the state's saying, this is the motive for the crime. You cannot understand this crime without it, because if it doesn't come in, then it allows the defense to say, why would he kill the mother? He has spent 2 years of his life helping this child while the mother was in prison. This is the daughter of his wife. It would make no sense. And that's a pretty good argument. So to me, the jury is not told the whole story without it.
The motive in this case, according to what the state alleges, is not that he killed Autumn so that he could continue to have sex with Sonny. The motive is to retain custody of Sonny, and there's dispute as to why he and Kathy wanted to regain custody of Sonny. The state says, well, it was so he could continue to molest her. He and Kathy say it was because John Trout was molesting her, because her living conditions were horrible.
But that's for the jury then. That's a jury issue. But how did the judge limit any of the testimony? What testimony, and again, when we do this feature of the trial, it's really the trial court has to be the manager of the trial and make decisions. Did the trial court limit any information or evidence? And if not, at what point, once the judge says it's going to be let in, did the trial counsel say, well, if you can let it in, but you should let in just a little of it? And so where did the judge abuse its discretion?
Okay, the judge did not limit any of it, and defense counsel did renew his objection prior to Sunday testimony.
Was it just an objection to everything coming in, or did the defense lawyer selectively say you should let the neighbors testify, but don't let Sonny testify?
The defense's position was don't let any of this in, but he did on several occasions, particularly prior to the discovery of the dildo, say this is becoming the feature of the trial. I already told you this would happen, and it is happening. Now, I think it's important to note this. The judge did not limit any of it. He did not exclude any of it. The argument was made by the state in its brief and by the prosecutor below, essentially, hey, if this becomes a feature of the case, it's not my fault. They're contesting it. They're not admitting it. So now I want to say that the following things were brought in by the state in its case in chief on direct examination of its own witnesses. 13 witnesses testified about this child sexual abuse, which this court recognized how prejudicial that can be in McLean. I also want to cite the Fourth Circuit in Ham.
I can understand that, and
Right.
really, there is a point when these things can become a feature of the trial. But what I'd like you to tell me is at what point and what witnesses, or if you can, really took this over the top?
Well, I think certainly Sonny took it over the top. I think the testimony about...
You mean the victim, the alleged victim, her testimony?
Right. I think, yeah, what I want to say is the following things. To rebut the state's argument, well, this is the defense's own fault. The defense made it a feature. Following things brought in by the state and its case in chief on its direct examination of its own witnesses. Sonny's in-court testimony accusing Roy of repeatedly molesting her. Sonny's pretrial statements to Sergeant Gross and Investigator Cohn identifying Roy. The dildo found in the car trunk and Roy's statements concerning that. Sonny's DNA on the dildo. The 4 neighbors concerning what they
Let's just go to that one.
Okay.
Sonny's DNA on the dildo. You saying, that alone probably is, it's certainly as prejudicial as it can get, and it is directly relevant to corroborate what Sonny says. I don't see how that doesn't come into evidence.
Well, it's relevant to corroborate what Sonny says. I suppose it has a degree of relevance. It doesn't.
You really can't say that with a straight face. If it was just the dildo,
right,
and didn't contain any DNA, the fact there is a dildo in the vehicle might mean, and that came in, I could see your point. But when it's linked up to the person who says that he was sexually, that she's accusing of sexually molesting her, I'm not seeing it.
He said at one point that he found it in her dresser drawers, and it's not inconceivable if you, in the entire context of this case, and in terms of Sonny's life history, and I'm not blaming her because her life history started this way at an age of 5 or probably earlier.
That
but
is,
it's not impossible that she used it on herself. It's not even implausible.
Well, if she didn't testify, you said it was a problem that she testified. If she didn't testify, wouldn't they be faced with the argument that you just made?
Well, okay,
why didn't she say anything to the investigators?
Well, essentially, we're back to the point of my position is any of this is too much. I am arguing that it became the feature of the case, but I'm not backing off from the position that any of this was too much. In terms of the relevancy, it was a two-jump motive. It was not, at best. This is, the state says, well, we don't want to say he just wanted custody because, John was molesting her, or because she was living in a drug-infested neighborhood, or because her mother, who with a 9th grade education and a 1st grade reading level, wanted to homeschool her. Well, this is not what this trial was supposed to be about. It became about this.
Why doesn't this show motive?
It does. I'm not claiming that it doesn't have some degree of relevancy to show motive. I'm saying that is greatly outweighed by the enormous prejudice that it contains.
So you're really making a prejudicial argument.
I'm making a 9403 argument. I'm also, like I say, I'm not retreating from the argument that with all the problems with Sonny's credibility, the state acknowledged to the trial judge that there were problems with Sonny's credibility. The state acknowledged to the jury that there were problems with Sonny's credibility. And so they're saying, well, therefore, we have to truck in all this other stuff.
But we have credibility issues all the time with witnesses, but it really seems to me that it is up to the trier of fact to make some decisions about the credibility of the witness. And yes, she had accused a number of people of sexually molesting her, but that does not negate the fact that she says that this defendant did that also.
And what you're saying would be absolutely right if, as Justice Perianti pointed out, if the state had charged him with molesting Sonny, and if this had been a trial for molesting Sonny, then you're right, it would all be a jury question. But the problem here is this is a trial for allegedly murdering Autumn. And it became a trial about molesting Sonny. It became a trial about Sonny's credibility. And you say
because
it's a jury.
It was important. Without a body, it certainly seems to me that it really is important for the state to then try to link this up by demonstrating that this defendant had, a real motive to kill the victim.
We have a weak case, so we're going to artificially make it stronger by making the trial about something else.
Well, that's not, this is the problem, and I understand that, listen, when collateral crime evidence comes in like this, you go from one, this is a great stepfather that was trying to help her, as you said, get out of a drug-infested neighborhood and get away from a mother who was herself in jail, in and out of jail. And you go, wow, this is a sympathetic guy. And then you find out, the jury finds out that he is systematically molesting this poor child. Yeah, it changes it. And
sure it does.
And there is always a problem when collateral crime evidence comes in that where it wasn't already a convicted crime, that you're going to have to weigh this. But again, you're saying there were 13 witnesses that testified, but that, are you saying if we should look and see, should the judge have limited to 4? And that's why I'm asking you, if the defense lawyer said, well, listen, if it's going to come in, then I would ask that it be limited to these 2 witnesses and this evidence, because otherwise it will take over the whole trial. And if that wasn't done, how can we say the judge abused his discretion or her discretion in allowing it in as a threshold matter, since you already said it has relevance? And that's what I'm trying to figure out. Which of the testimony took it over the top? And you're saying, no, it was everything. But then you have to be able to say, if we were to give a new trial and say it was relevant, which part would we say took it over the top?
Well, I mean, again, my position is, and you say it was relevant. I concede that it was relevant.
But when in the weighing of whether the prejudice outweighs it,
right?
And if it becomes a feature of the trial, it's not a quantitative. It's qualitative and quantitative analysis. And so I'm still asking, you said Sonny shouldn't have gotten on the stand. And I think all of us here are sort of saying, well, but Sonny, of all the people, if anything was going to come in, Sonny and one of the neighbors should have come in.
I mean, what I'm saying is I think the nature of this evidence, to be frank with you, I don't think there's any way that you could remand it and just say, well, only a little bit of this should come in. I think that because of the 9403 problem, because of the credibility problem, and because of the overwhelming nature of how prejudicial child sexual abuse is, that none of this should have come in. So I think that in addition, you're talking about how, that he might seem like a sympathetic step-grandfather, and then this comes in and it shows that he's actually a monster, is what the jury's going to hear. And this was incredibly prejudicial as to the penalty phase as well.
There was some pretty good evidence that he was the person that killed Autumn. I mean, it wasn't as if, well, they're going to decide that he killed Autumn because he molested his step-granddaughter. I mean, he's the last one seen with her. He gives a story about how he was, they bought sodas together, and that didn't happen. He left work. His cell phone records established that he was right at the scene of the crime. So there's a lot, and plus his confession. So there's a lot of circumstantial and direct evidence that places him as being the murderer.
Okay. I'm sorry. I'm sorry to interrupt there. I'm not sure where the cell phone evidence didn't place him at the scene of the crime. They don't even know where the scene of the crime was, if there was a crime. The cell phone evidence places him in North Polk County, not far from his home.
Did they have blood evidence for Autumn in his car?
There was some blood on a Walmart bag, so a couple of spots of blood on a Walmart bag that matched her. There was a spot.
And so why doesn't that then slide over into I believe it's Crane, the case where the fellow, and there was nothing that placed him there other than a few droplets of blood on his underclothing.
Well, I mean, again, you have to, this is a case. Was the evidence sufficient? Absolutely. I did not even challenge that. Was it overwhelming if that was even the test? Clearly not. Even the prosecutor acknowledged before trial that this is not an overwhelming case as to guilt for a variety of reasons. He also acknowledged that it's not an overwhelming case as to penalty. But if you're considering the guilt phase as to what extent the evidence regarding Sonny could have affected the jury, you got to consider the defense witness Wilma Granert and the defense neurologist as well. Wilma Granert was a witness who, as far as anybody, had no axe to grind, had no reason to want to testify. She testifies that she sees a woman who she recognized from the flyers as Autumn. In addition to the fact that she recognized her, one of the other two women that was with her calls her Autumn. Now, that name isn't like Brittany. It's not a common name these days. So Wilma Grenner says, to her boss, should I go to the police with this? And he says, no, don't bother. They have the videotape. The police came to her, so there's no reason. She has no axe to grind. She doesn't know these people. She didn't necessarily want to get involved. She knows that the date was Wednesday because she's off on Sunday, Monday, and Tuesday. She starts work on Wednesday. She spoke to the police on the 21st, which means that she came forward well before that, so she's talking about the immediately preceding Wednesday. So this is a case where the jury could, yes, the evidence was legally sufficient, but is this a case where, but for hearing this overwhelmingly prejudicial evidence, that the jury might not have acquitted? Absolutely not. They may well have acquitted.
Well, I don't think, but now you're talking about a harmless error analysis.
Which the state didn't even argue.
And I don't think they could argue that. Right. I mean, obviously, if this testimony for some reason wasn't admissible, it would be, I don't think there's any question about that. But I guess we're going on this issue as to whether becoming the feature of the trial and whether there was a lot of other evidence that placed him as being the murderer in this case. And you were saying, well, there's other evidence that shows he might not have been. That was put into evidence.
And I also wanted to make the point, I think it was you that had brought out about how, he might seem sympathetic, and then this comes in and he doesn't seem sympathetic at all. Autumn Traub was not a sympathetic victim. There's a reason why there was no victim impact evidence in this case. This is not a person that the jury would have necessarily empathized with much. And in his closing argument, what does the prosecutor do is argue, basically about Sonny's life and how Sonny is age 13 at the time. She's in the business of paying rent with her body. This is Sonny Hotland's life. Okay, this trial shouldn't have been about Sonny Hotland's life. It should have been about what happened or didn't happen to Autumn Traub. If I have any time left, I want to turn briefly to the ring issue.
Well, now, you are now into your rebuttal time. You have a total of 5 minutes and 46 seconds left.
All right, I'll stand on the briefs then as to the ring issue unless it comes up in the state's argument, and on the proportionality issue as well. Thank you.
May it please the court. My name's Stephen Ake. I represent the Attorney General's office here on behalf of the state of Florida. I'd like to address the trial court's discretionary ruling admitting this evidence of the sexual abuse by the appellant to a step-granddaughter. And the state's position is obviously that it was relevant evidence under 90.402, and that the trial court properly did the balancing test of 90.403 and found that its probative value was not substantially outweighed by the danger of unfair prejudice in this case.
Well, now, your opponent argues that there were 13 witnesses who testified concerning this sexual abuse. I certainly understand the victim coming in and the neighbors who would have no axe to grind, who observed what they say they observed between the defendant and the victim, and the dildo that was found in the trunk of the defendant's car. Well, what beyond that was necessary in order to demonstrate that this was a possible motive for this crime?
Your Honor, on page 34 and 35 of my answer brief, I put forth the 13 witnesses, and it was 13 out of 40 total witnesses that testified to this.
13 out of how many?
40.
40 witnesses.
Testify. And I would submit, and I put the page numbers that they touched on in the state's direct examination. Most of these witnesses were relevant to other areas, and they touched on the sexual abuse in addition to much other relevant evidence that they had in this case. For example, John Traub, the victim's husband, he testified at length as to all kinds of stuff, and just briefly, it was like 2 pages mentions the sexual abuse allegations. Really, it boils down to the 4 neighbors that were eyewitnesses to the abuse. The law enforcement testimony regarding the seizure of the dildo and the DNA testing of the dildo, there were a number of DNA type people that took testing and then the results. And then you have the statements by the child herself and the various statements to detectives and to a state attorney investigator, and the statements from, or the testimony from the child herself at the trial. Those were basically, and an inmate witness also made brief mention of it too. So those were the 13 witnesses, but all those witnesses, for the most part, had other relevant evidence to testify to in this trial, but they still touched on this. So the fact that it became a quote-unquote feature of the trial is just not true based on a qualitative or quantitative analysis in this case. Is you look at either one of them, and it's just simply not borne out in the record.
Did the defense take the position in the trial that the abuse did not happen?
Yes, Your Honor. I believe that's exactly what their position was, that the child was giving inconsistent statements because it did not happen. Counsel briefly said something about the dildo being found and said that the defendant's story was that he had found that in Sonny's dresser. That's not accurate. What took place was the defendant's wife testified at trial that that's what the defendant told her, and she was impeached with that, and that she told detectives immediately after the crime occurred that she didn't know where that came from, that she had never seen it before. And you have to remember that the law enforcement officers did a consensual search of the vehicle at Mr. Ballard's house with both Mr. Ballard and his wife present, and that's when they discovered the dildo in the trunk of the car. And at that time, the wife says, "Hey, Roy, where'd you get that?" And he says, "None of your business." Mr. Ballard denied knowing where that dildo came from to the detectives when he gave a statement and said, "I don't know where I got it from. I don't remember. I found it somewhere and I was going to throw it out." He never claimed that he had found it in Sonny's dresser. That was something that Kathy Ballard came up with at the time of trial and was impeached on that fact. So the dildo is very strong evidence because it does match up the DNA that it was linked to Sonny. It was very much the state's whole entire theory of this case, and their theory of prosecution was the motive for this murder and this planned murder was that he had lost custody of the child in August of 2006. She had moved back in with her mother, and within a matter of weeks, he was making plans. He had tried to regain custody of her. It didn't work out. He went to Lowe's and made his purchase of this lead pipe and is beginning his planning of it. And it was only...
Did he also purchase some tape at Lowe's?
Correct.
Was that tape used? I mean,
Yes.
when they found it, had some of it been...
Yes, Your Honor. It had been torn off. They didn't make a determination as to how much of it had been used, but they did say that it had been torn off. And there was a blood stain found on the inside of the cardboard section of the duct tape that was matched up to the victim, as well as blood stains on the Walmart bags in his trunk. There were 2 blood stains that were matched up to the victims. And of course, the duct tape was only purchased 10 days or so before the murder, and the victim had absolutely no connection to this car whatsoever and was hardly ever even at the Ballard's house, I think, but for a brief moment. So there's no way that blood got on there except at the time of the murder. And curiously, the appellant says that he tells police in his statement that he goes to Lowe's on September 2nd, the murder's on the 13th, I believe. He says, "I go to Lowe's, I buy this lead pipe. I don't know why I bought it. I don't know what I used it for. I don't know where it's at." He doesn't know any of that. And he says, "And then I grabbed this roll of duct tape on the way out because I thought it would be useful at work." The whole reason he went to Lowe's was to buy this lead pipe that was 18-inch lead pipe that's never been discovered, and that he told an inmate that he ground up at his work after the murder. So
He told the inmate he used the lead pipe.
right, to kill the victim, and then he ground it up with the machinery at his workplace.
Could you just address proportionality and the 9-3 jury verdict on CCP?
Sure,
First
Your
of all, what was, he didn't, there's no aggravator of a prior violent felony, but they also didn't seek the mitigator of no significant
Correct.
history. Do we know from the record what, and he's 65 at the time of this crime, working, what his past history is?
No, Your Honor. He had waived the PSI, and the trial court made a mention of that in a sentencing order. That
So we don't know
what his prior criminal record is.
And the state didn't uncover
No, Your
prior
Honor.
felony convictions?
No, Your Honor. The only aggravator in this case, and it is a weighty one, is the CCP aggravator.
So tell us, evaluate any of the mitigation, because with a single aggravator case, the mitigation, of course, becomes
Right, and the state and the trial judge was aware of the case law from this court that said that in single aggravator cases, there must be very little to slight mitigation, and that's what the trial judge found. Now, curiously, the trial judge finds 3 statutory mitigators, the 2 statutory mental mitigators and the age mitigator. But if you actually read the trial judge's order, he really doesn't find those 2 statutory mental mitigators. He finds that both of them have been rebutted by the state's evidence, but he nonetheless says, I find them and give them very little weight. But I think it's important to note that there really is nothing substantial in this mitigation besides the fact that he is an elderly gentleman that had some health issues. None of that was linked up in any way, shape, or form to the crime in this case. They tried to say that because of these strokes and seizures that he had brain damage that caused him lack of control of his impulses, but this wasn't an impulsive crime. This was
When did
something
he have the strokes and the seizures in relationship
right after
to
he
the crime?
purchased the lead pipe. It was the following day or the following evening that night when he was in bed. I believe it was the 3rd going on the 4th of September that he had a number of seizures or strokes and was sent to the hospital, and he was hospitalized for almost a week. And then he was let out of the hospital on a Friday. Took the weekend off and then returned to work on that Monday, and then it was the Tuesday and Wednesday. The murder was Wednesday, but Tuesday he took off that day, didn't tell his wife, and went and the state's theory was he was plotting out where this murder was going to take
And what
place.
about go ahead.
Did the cell phone records indicate that he was in fact in Lakeland on that
Correct.
Tuesday also?
Tuesday evening at 6:08, I believe, was the time that he was there, and he had never told his wife that he had left work early that day. He had no reason to be in that section of North Lakeland. It was, as the trial judge found, that was not in any way a link to where he would go to and from work or to the victim's residence. It was totally separate, very isolated, wooded area where that was at. And that was the same cell phone tower was utilized the next day when the wife called on her lunch break at like 11:16. That's where the phone hit again, that same cell phone tower, and that was on the Wednesday, the day of the murder, when he was supposedly home, is according to his statements. He testified, or he told he didn't testify, he told the detectives that he went and picked her up. They went and got this soda, drove around, and he went home and was home by 9 a.m. And when his wife called at 11:16, he presumably, according to her, was at work. She didn't know any better, but he was in North Lakeland at that time. So.
What is the state's best case of this being a proportionate sentence?
Sorry, I got away from that, Your Honor. I would argue maybe Lamarca. I haven't found any case that deals directly with a single aggravator being CCP. The majority of them are HAC is the single aggravator. I haven't found a single one that was just CCP, but in Lamarca's case, it was HAC. There's a couple other cases.
Lamarca had just HAC?
Yes, Your Honor.
What about Songer?
Or
Songer
actually,
is one of-
Lamarca, I'm sorry, Your Honor, I might have confused that. Lamarca, I think, was a prior felony conviction. I'm sorry, I was confusing that case with another case. Butler is the case I was thinking of. I'm sorry, Your Honor.
Now, Songer is one of those cases that was a single aggravator case that we actually reduced to life. So what is the difference in the mitigation that was in the Songer case and in this case?
I don't recall off the top of my head exactly what was in the Songer case, Your Honor, and I apologize for that, but I don't remember what all the mitigation was in that one, because that's not one that was really utilized. I think the trial court was looking at Crook, which was one that they were relying on. There's been a number of cases, and I will concede that this court has reversed cases where there's been single aggravators, and the standard language this court uses is that there can only be slight to little mitigation in that case in order to affirm a single aggravator case.
And in Crook, there was substantial mitigation.
Right, there was substantial, and that's...
Let me go to a question that is obviously it's going to be a matter of law, and I think the majority of the court, may have already made these determinations, but this ring issue, this lingering ring issue, the jury wasn't told, or was it, that their verdict as to finding one or more aggravators had to be unanimous? Is
No.
that correct?
No, that's correct.
And it's the state's position that because, is it the state's position that because death is the maximum penalty for first-degree murder, that in Florida, that Ring does not apply at all?
Correct, Your Honor. That would certainly be.
And if that were the case, and the problem, and we'll see what Justice Scalia thinks about it eventually, is that would really, the whole idea is that if every case in Florida, the maximum penalty is death, the statute could be unconstitutional as having too much of a web. I mean, it really,
Well, I think the guilt phase is that eligibility determination, and then the Florida legislature set it up to use the second phase as the narrowing, phase of it, and I think that would pass constitutional muster with the U.S. Supreme Court. They certainly have had their chances.
right. But this case. There was Butler. I think it was the only other single aggravator case that I know of in the last 10 years where it wasn't a prior violent felony.
Well, there's
also.
three, Your Honor. Actually, there's Butler. There was Code, which was reversed for other reasons, but the court addressed the Ring issue. And then just a few months ago, Abdul. And that was one that we talked about extensively.
Abdul had, what was the aggravator there?
They were, it wasn't a single aggravator, but it was HAC and CCP. It was what Mr. Bolison would refer to as a pure Ring case. There was no prior conviction. There was no unanimous verdict or what have you like that. But Abdul was just a recent, I think it was October maybe of last year when this court came out with that decision. But as you pointed out, Butler, which was soon after Ring, was a single aggravator case, and that was the HAC case that I was thinking of earlier. But in all those cases, this court has had the opportunity to recede from, I guess, Bolison and King versus right when Ring came out. And the state's position is that there's no reason to find that the statute's unconstitutional. If there are no further questions, I will just ask this court to affirm the conviction and sentence. Thank you.
State relies on Lamarca for its proportionality analysis. Lamarca is a case where the single aggravator was prior violent felony, and the court made a large point of the fact that the murder in Lamarca occurred very shortly after his release from prison. He was released from prison where he'd been serving time for kidnapping and attempted rape, and those crimes occurred after a still prior release from prison. In the instant case, Ballard's crime, assuming, I'm conceding for purposes of this argument, guilt. I'm not conceding it as a matter of fact. But this crime occurred a week after his release from the hospital where he'd suffered a stroke, after he had a history of strokes, but he had suffered another stroke, and he was Baker Acted. He was Baker Acted upon a finding of psychosis, NOS. You can't Baker Act somebody just because they're refusing treatment. You don't want them to.
When was he Baker Acted?
But isn't there then evidence that he was, that would support the conclusion that he got to be all right, and he went about his business, and that episode he had been resolved?
Not really. According
I understand that it might be disputed, but isn't there evidence that would support that conclusion?
I don't believe there is. I think there's Dr. Vyas who testified that at the time of his release, Dr. Vyas is not a neurologist. He acknowledged he didn't do an exam the way a neurologist might. He said that he didn't observe any neurological deficits, but then he was shown the nursing assessment, which showed at least 3 examples of left side neurological deficits, and he then acknowledged that, yeah, actually I did observe one of those.
When was the Baker Act in relationship to the crime?
When was he Baker Acted in relationship to the... He went to the hospital on the 4th. He was Baker Acted, I believe, on the 4th or the 5th, and the crime occurred on the 13th.
And explain again why he was Baker Acted. He had a stroke and epileptic seizure. Why was he Baker Acted?
He was Baker Acted in part because he was wanting to go home. He was combative. He had to be tied down to his bed. There's evidence that he was saying stuff to Sonny, like that he loved her and wanted to marry her, which freaked her out because it was nothing like anything she even said that he'd done before. So I think that he was certainly displaying irrational behavior.
But once he was released, and he went home on a Friday, went to work on that Monday, and don't we have evidence from where he worked, the gentleman who was his supervisor, that he was acting as his normal self except for that Tuesday when he seemed tired and he told him to go home.
Well, in addition, on the first day after work, he was, because again, he didn't seem like himself, he was given paperwork to do. I mean, how much is a work supervisor at a metal shop going to know about, impulse control? And whether or not you're on too much Dilantin.
The problem there is, though, because what you're saying is that the judge didn't weigh the mitigation, the mental health mitigation. He didn't give it either. He gave it slight or no weight.
He didn't give it no weight. He found them, and he gave it slight weight, just like in Almeida, by the way. But what I'm saying is the rebuttal doesn't rebut anything, and I'm not arguing credibility. I'm talking about the scope of the rebuttal. The rebuttal in this case, the pathologist who doesn't examine live patients in Witzigman does not rebut any significant part of the defense's case. I need to address the ring issue just very, very briefly. The state says it does not apply in Florida because the maximum penalty is death. Number one, that's exactly what Arizona said in Ring. Number two, it isn't true. Under federal constitutional law, it's unconstitutional to impose a death penalty without a narrowing aggravating factor. Florida has recognized that as well, and under Elam and Banda, death is not a permissible sentence in Florida without an additional finding and aggravating circumstance. That finding can be made in the guilt phase if it's the felony murder or aggravator or something like that doesn't apply here. But the finding of premeditation in the guilt phase does not suffice because there's 4 additional elements of CCP. So there is an additional finding, and under Ring, a jury must make that finding. The state cites 3 cases. Butler was raised very briefly only on a motion for rehearing, and it's before Steele. Code, also before Steele, is a 3-judge opinion, so it has no precedential value, and it's dicta anyway because Code received a new penalty phase on other grounds. He later committed suicide in prison. That leaves only Abdul. This issue could have been raised in Abdul, but was not. The brief in Abdul on the Ring issue is 2 pages. All it says is, please recede from Bolison and King. Court doesn't have to recede from Bolison and King. Bolison and King didn't garner a majority. They were successive post-conviction cases. They had prior violent felonies, and I believe King was a unanimous jury rec. This case is nothing like Bolison and King. The court doesn't have to recede from Bolison and King. The court doesn't have to rewrite the statute. All the court has to do is realize that the death penalty cannot constitutionally be applied against Roy Ballard based on Ring. Do what the Delaware Supreme Court did in Cabano.
But Ring has never said, or any of the subsequent cases, that the finding by the jury needs to be unanimous, has it?
The majority opinion, the majority opinion in Ring doesn't say that in so many words, although it has been interpreted by courts of other states and federal circuits as meaning that. Justice Scalia, in his concurring opinion in Ring, definitely does say that, plus which under Florida law, there is no precedent for non-unanimous jury verdicts, and under federal law, Apodaca and Johnson specifically exclude capital cases from the statutes they were reviewing. Thank you.
All right, we thank you both for your arguments. The court will now take a 10-minute recess.
Rise.
We now take up the third case on our docket, State Farm Mutual Automobile Insurance Company versus Menendez.
Good morning, may it please the court. I'm Warren Quavnik on behalf of the petitioner, State Farm.
Could you speak up just a little bit?
I'm sorry, is this better? Okay. I believe I've reserved 5 minutes for rebuttal. This case involves the application of the household exclusion in State Farm's automobile liability policy as it applies to claims by resident family members of a permissive driver who is herself uninsured as defined in the policy. The facts can be very briefly stated. The named insured under the policy is Gilda Menendez. She's the grandmother. She allowed her granddaughter, Fabiola, to drive the described vehicle. Fabiola is driving it. Riding as occupants are her parents, as well as grandmother herself. Fabiola and her parents reside together at an address separate from the grandmother, but they do reside daughter with parents. Accident happens, and the coverage issue that emerges is whether the grandmother's policy covers the claims of the parents of the permissive driver.
Well, first, was there an issue of, was there something where the granddaughter was trying to get coverage of some sort?
Initially, there may have been a claim along those lines. I don't think once the case, assuming they ever were trying to make that claim, by the time it got to the third DCA, they were not claiming coverage for the daughter's injuries or the grandmother's injuries.
So there is no question that the granddaughter was an insured under the policy and
No
as
question.
a permissive user.
Correct.
And of course, if they all lived in the same household as the grandmother, then we really have no issue.
Right. Yes, and the exclusion says in relevant part that there's no coverage for any bodily injury to any member of an insured's family residing in the insured's household.
Is it just turning on, if it had just said in an insured's household rather than that would have then, even the third district would have said that's not ambiguous?
I think they would have, but keep in mind, that's a broader exclusion than what this is. If it said any insured's household or an insured's household, that's more than what this exclusion is. That would be a broader exclusion, because what then that would allow you to do is say family members of one insured who reside with any other insured are excluded. The way we read this is the insured's household refers clearly and unambiguously back to the same insured referenced earlier. So here, because we're talking about a permissive driver insured, whose family members were injured, it's that insured's household that matters. So we could have said any insured or an insured's household, but that would be a greater exclusion than this is, and certainly we don't have to make the exclusion broader than is intended. And that is exactly what the third DCA held. What the third DCA said was, even though the bold and italicized word insured is defined to include not just the named driver but permissive drivers, they said it's reasonable to construe the phrase the insured to mean only the named insured. And as a result, what happens here is family members of a permissive driver who reside with her have coverage because they don't live with the named insured. They have to live with the named insured instead. And we think that's an unreasonable and illogical reading of the policy, which conflicts with at least 3 cases. This court granted review based on conflict with State Farm versus Reed and Linehan versus Alcabaz, both of which applied substantively the same household exclusion to claims brought by permissive drivers, by family members of the permissive driver. On further research, I think that there's conflict clearly with another decision out of this court's decision in Webb versus American Fire and Casualty. That case involved the policy exclusion that said there's no coverage for injury to an employee of the insured. And this court said that exclusion extended not just to employees of the named insured, but employees of the permissive driver insured, because we have to apply the policy definition. That's exactly contrary to what the third DCA did here. So we think based on conflict with any of those cases, this court...
Reed is a State Farm case also, correct?
It is.
And is this policy language identical to the policy language in Reed?
Well, Reed gives us not a quotation of the policy language, but it sets forth the substance of the exclusion, and certainly in substantive part, it is functionally the same as what this one is. What it's in pertinent part, what it says is I can read it to Your Honor. It says, the way they described it is they said, this insurance does not apply to bodily injury to any insured or any member of the family of an insured residing in the same household as the insured. So we have the same an insured, the insured construct like what we do in our case. So I think in relevant part, it is substantively the same exclusion.
And in Reed, it clearly said that this kind of situation would not be covered?
Right. The analysis in Reed was daughter has a claim. Sister is driving her sister. They reside in the same household. The court was clear that the sister driving the car was a permissive driver. It was the father's car. She was a permissive driver. She was an insured. Sister lived with her. Therefore, the exclusion applied.
Can you have two separate questions? One is what is the best out-of-state case against you on the same language, if there is one? Is there one?
I don't know if there is one. My research turned up the Missouri Supreme Court case of Balmer, which is directly on point. I know it's not binding on this court, but I think it sets forth a highly persuasive analysis here of this exact policy language. So I don't know. I don't think we've been cited to any out-of-state cases, and frankly, I don't know of any dealing with this exact language.
This is I would assume is this a standard exclusionary clause, or do we know? I know that we've had other cases where some insurance companies say it differently or better, or they should have said more or less, and do we have that here?
I don't know if other insurance companies use this same exclusion, and as far as whether State Farm uses it throughout the country, I don't know that either. I know at least they must use it in Missouri.
Okay, now the other question I have is just State Farm clearly is saying, listen, we intended this exclusion, this household exclusion, to mean exactly what we're saying. It's not a strain reading, it's a logical reading. Just explain from the insurance underwriting policy point of view why the same policy reasons, that is why you exclude coverage for anybody residing in the named insured's house being able to sue, applies to permissive users and their household members.
Okay, well, I've addressed this in my reply brief, and I think actually the policy reasons probably apply even greater in this context. The idea is resident family members are likely to collude with one another. Now, I would think resident family members in a borrowed car, whose policy isn't even at issue, would certainly have maybe even greater reason to collude to get the coverage under the named insured, someone else's policy. The very same policy considerations are here, but without the downside of maybe an increased premium that would come along with it. So I think certainly the policy considerations apply equally, if not more so, in this context. And as far as to deal dead on with the ambiguity issue, there is no ambiguity here. When we use a sentence structure like this, that there's no bodily injury, there's no coverage for bodily injury to family members of an insured residing in the insured's household, it's very clear, I think, that the insured means the one referenced earlier. And I think I may be able to make it clear with a very common example. If I was to say, if you see a friend, tell the friend hello. Well, who should you say hello to? Which friend? It's clear. The one referenced earlier in the sentence is the one you saw. So there's no genuine ambiguity here. You couldn't contend you didn't know which friend to say hello to.
But your argument, which is actually, it's maybe equally strong or stronger, is that if they used the what is that?
Preposition?
Preposition.
I think it's a preposition.
Whatever it is, and
right.
The second time,
yeah, it's broader.
It might mean that it excludes, even if they weren't living in the named insured's household and they were trying to sue the named insured.
Right, so long as you had a situation where a family member was related to an insured, so long as they lived with any other insured, there'd be no coverage. And I think State Farm has tailored this exclusion to meet the very purpose of it, which is what I said, keep resident family members from colluding in lawsuits with each other.
Then is the case that they can sue, because the grandmother is vicariously liable?
Yes.
And they sue the grandmother and just not...
Well, they can certainly sue the grandmother. There wouldn't be coverage for that, and that's an issue that I think the Florida Justice Association stumbled onto in their amicus brief. The coverage here isn't dependent on who can be liable or who can be sued. The policy doesn't cover claims by resident family members of an insured. It doesn't matter who might be liable, so long as the injury is to a resident family member of an insured. The policy just doesn't provide coverage for it, regardless. And I think that's clear. In fact, the parties in this case haven't taken a contrary position to that. And the other thing I think that's important to point out is if the exclusion were meant to apply only to the household of the named insured, it would have said your household. You is defined in the policy to mean named insured. When they mean to describe only the named insured, that's what they use. Insured used here again is a bold, italicized, defined word. It's entirely wrong to strip it away from its defined meaning. And really, those are all the points I wanted to make. I could address some of their arguments, and I think I probably have the time to do that. Cochran is a 4th District case that they rely upon heavily for the proposition that the insured means the named insured. Cochran is not controlling here for a number of reasons. One, I think it was incorrectly decided from the outset because it's inconsistent with this court's Webb decision that I described earlier. Webb again applied the definition of insured, including permissive driver, to the phrase the insured, exactly contrary to what Cochran did. The other important point is, whether even if Cochran was correct, it's not on point here. Cochran dealt with the first part of the exclusion that we're talking about here. At the time, Cochran said there's no coverage for bodily injury to the insured, period. Today it says an insured, by the way. Here we're dealing with the second part of the household exclusion. It says there's no coverage for bodily injury to a family member of an insured residing in the insured's household. The insured is not used here in a vacuum. The insured is used here in a context that clearly relates back to an insured. So even if Cochran were correct, it's distinguishable and doesn't govern here. And in fact, the Cochran Court, the 4th District Court of Appeal, went on later to decide the Linehan case, which applies the household exclusion exactly the way we say it should be. So clearly even the 4th DCA doesn't consider Cochran to govern this very scenario. And as far as the Linehan case goes, the argument has been made, well, that's not a conflict case because all the court did was address the validity of the exclusion. And I think it does more than that. Cochran came just a few years after Reed, so the validity of the exclusion was established. Linehan gives us the substance of the exclusion, which is substantively the same as ours. They give us all the facts.
Was Cochran decided before Reed?
Cochran was...
Or after? I thought Cochran was decided before Reed, and so my question really was,
is it even
was
good
that
anymore?
Sort of did Reed in any way overrule that?
Well, you're right. Cochran was 3 or 4 years before Reed, and it may have been rendered invalid on that basis as well. But certainly, at the very least, it's just not controlling on the question here. Keep in mind also, Cochran was an opinion by one judge, another dissented, and another concurred only in result for whatever weight the court wants to give that opinion. I think if there's no other questions, I'm inclined to reserve the rest of my time for rebuttal if I can do that. Thank you.
May it please the court. Lori Waldman-Ross on behalf of the Giannis's, and with me is my colleague Gonzalo Dorto, who represents the named insured Menendez. Let me address two things right off the bat. The issue of jurisdiction. The only thing that Reed decided was that household exclusions were valid. It did not address, and the issue was not raised as the ambiguity of a particular exclusion. We have never contested that A, household exclusions are valid in Florida, or B, that State Farm's exclusion is not valid in particular. The only thing that was at issue in this case was the ambiguity of this particular provision as applied to the facts of this case.
So you disagree that Reed actually says that the permissive user's household, the people who live in the household with the permissive user are also excluded?
I disagree with his assertion that that was the holding of this case. And in fact, this court has always said, and said in the DeBose case, that a case does not stand for a proposition that was never raised before it and cannot be controlling authority on it. And the fact in this case was ambiguity was not raised in Reed. The issue before the court was whether or not, and this is how the issue arose. The issue before the court was whether or not the passage of the Florida Reparations Automobile Act, the passage of that act invalidated household exclusions. And what this court held was, no, it didn't. There were a series of other cases as this court went back and forth over whether or not intraspousal immunity should be abolished or not. There was the Florida Farm Bureau case in which somebody raised the issue of whether or not passage of the Contribution Among Joint Tortfeasors Acts abolished household exclusions. This court held it did not. Every time a new act was passed, the issue came up whether or not those acts abolished household exclusions. This court says, no, they didn't. But whether or not household exclusions are valid is a different question from whether this specific exclusion is ambiguous. And that is the issue before this court. In Linehan, the court raised the issue of validity of the household exclusion. You don't know what the arguments were with regard to ambiguity, whether it was raised as an issue, because it's not addressed. The only thing that the Fourth District says in Linehan is that we have considered the arguments raised as to whether or not Reed controls or not, and we find them not to have merit. But they have no discussion about ambiguity. So let's go back to the facts of Reed. In the facts of Reed, I mean, assuming we get past that issue, and the reason I say we get past the jurisdictional issue, because jurisdiction is a threshold issue. We came here on 2 alleged conflict cases, Reed and Linehan, neither of which address the issue of ambiguity. In Kyle versus Kyle, out of this court, a controlling jurisdictional case, this court said, and the issue was, a prior issue had been raised with regard to validity of a will. And this court says on appeal, another issue got raised as to conflict contesting ambiguity of the will. This court held the issues were completely different, afforded no basis for conflict jurisdiction, and it went on to say, because an argument was made that the actual language in the will was in conflict with a decision of a state Supreme Court with another state court. And this court said that conflict between a district court of appeal decision and a decision of another state Supreme Court is not a basis for conflict. So when you look at what Reed actually held, which was validity, what Linehan actually held, which is validity, and then you look at what they've contested in this case, which is alleged ambiguity, there is no express direct conflict.
What do you say about Webb? Now, I realize that's something that came up in the when you've not had a chance to respond to it in your brief. So I give you an opportunity now to respond to it.
Webb has to do with an exclusion dealing with a different exclusion to begin with. It deals with a business employee riding in the car. But
on this interpretive question, okay.
It really doesn't square on address the interpretive question, but I looked at it after the fact because let me also segue into the change in the issues that have been raised on appeal. We start out with an initial brief, which says this conflicts with the law of Florida. The court misapplied Reed and misapplied Linehan. Those are the issues. We brief Florida law as it applies to A, jurisdiction, and B, ambiguity. New lawyer representing State Farm comes in, files in a reply brief which has nothing to do with the issues raised on appeal, goes far afield and raises foreign jurisdictional law, which of course we have not been able to respond to. So when he tells you there are no other cases, if you look at the Cochran Court, and I want to go back to Cochran because Cochran is an ambiguity case. And if you look at the majority and compare it with the dissent, judge, and this is what I found the most interesting about this case. The dissent says, and this is Judge Owen's dissent, he says there is merit to the argument that there is a distinction between an and the insured in these insurance policies. And in fact, there is authority standing for that proposition, and he cites a Patton versus Patton, which is a Pennsylvania Supreme Court case interpreting what? A State Farm policy, a State Farm exclusion. And there is a lengthy discussion in Patton versus Patton as to why the analysis that State Farm engaged in was wrong, because the omnibus insured provision, actually the definition of insured, was intended to add coverage to the policy. And Patton versus Patton is a case in which there were 2 injured parties, one of whom was married to the named insured who could not recover, and the other of whom was married to the omnibus insured who could recover. And the reason why is the court looked at the difference in the terms an and the and said that the insurance company was improperly relying on the definitional section, which adds coverage to additional people as contemplated by the named insured, which the named insured paid for. But when you're looking at the exclusion, you had to interpret that exclusion in terms of the exact language that was interpreted. So if we're talking about the reasonableness of our interpretation, we have the Pennsylvania Supreme Court going our way. We have the Missouri Supreme Court going their way. But the only issue that was before the Third District Court of Appeal was the reasonableness of our interpretation. And if two interpretations were equally reasonable, which they were under the facts of this case, then the court determined that it was ambiguous.
What about his argument, the distinction between the use of insured as opposed to the term you or your?
That is a distinction, again, that State Farm has come up with that simply isn't borne out by the policy. While they define you as named insured, there are plenty of other provisions in this policy in which they use the term the insured, where it clearly means the named insured. There's a mediation provision. There's a cooperation provision. There is a membership provision, all of which refer to the insured rather than an insured. And it makes perfect sense. They don't use the term you. They use the term the insured. It makes perfect sense because the policy specifically says that the definition of insured means person or persons defined as insureds in the specific coverage. So this particular policy has different definitions of the term insureds throughout. It uses different terms, an insured versus the insured, in referring to different things. And going to the grammatical issue, the term an insured is an indefinite article that means any insured.
So let me, on this, and looking just at the specific language, because whatever Pennsylvania says, Missouri says,
Exactly.
the Third District says, we're looking at this de novo. Correct. Okay. It's not whether your interpretation is reasonable. The issue is it objectively an equally reasonable interpretation?
I agree.
Okay. So I thought if they had used "an" in the second instead of "the," his argument is that would have unintentionally added to the breadth of the exclusionary clause. What do you say to that? And if you were saying how would they write this so it would be unambiguous, what would you say?
Number one, it doesn't add to the exclusion by using the term "an," and we were comparing and analyzing different factual scenarios.
Who was?
My co-counsel.
Oh,
my
you probably
colleague
had a
and I.
great deal of fun with this case.
Yeah, we have compared lots of factual
You're
scenarios.
now using co-counsel's time. So.
Yes, and he will go along with me as long as I don't intrude too far. But let's assume that Menendez. At least he's told me in advance.
A rueful expression on his face.
Let's assume Menendez, the grandmother, was driving her own car. It doesn't fall within the language of the exclusion. Why? And they're arguing the household exclusion. Collusion, fraud between family members. Why not? Look at the language of this particular exclusion. The exclusion says there is no coverage for any bodily injury to any insured. Well, that's the named insured. Or any member of an insured's family residing in the insured's household. No question that the granddaughter and her parents do not reside in the grandmother's household. So if Menendez was driving her own car, this goes to the reasonableness of our position, this household exclusion wouldn't apply at all. So use of
That's not the question. Of course it would not. You're right. But by saying, changing the facts and saying,
no,
it won't apply here, doesn't make it apply here. And the thing that troubles me here is that you don't get into construction unless it's ambiguous. And to be ambiguous, just because you have to do construction does not render it ambiguous. Because I've never seen an insurance contract that you didn't have to do some kind of construction.
And I agree with you. I mean, but ours is objectively reasonable because it comports with other provisions of the policy.
Well, but if you look at that immediate context, isn't it most reasonable to understand the uninsured in light of or the insured in light of the earlier reference in that same sentence to any insured. That seems to me to be a very powerful contextual indicator right there as to what that subsequent reference to insured means.
And that is a reasonable interpretation, but ours is equally reasonable.
Well, that's the question we have to decide. But that seems to me to be such a powerful indicator of what that word means in that context, that these other things about stuff that's done elsewhere in the policy, it seemed to me to be very insubstantial compared to that powerful indicator right there in the immediate context.
Okay, but Cochran used the term "the insured" as well, and Cochran.
Well, Cochran, that's very nice.
Okay.
I mean, Cochran.
No, you get to determine.
Cochran might very well be wrong.
Mm-hmm. But let's assume.
Did you give me how you would have written this so it wouldn't be ambiguous?
I'm sorry. How I would have written this, or how it could be written. Number one, we had two alternatives that it could be written. Number one, I'm sorry, I'm just looking for the exact language. There is no coverage for any bodily injury to any insured or any member of an insured's family residing in an insured's household or residing in such insured's household, because the such would refer back, but the term "the" does not, and "the" is a specific person.
You're now down to 6 minutes here.
Thank you very much, and thank you for the extra time. I respectfully ask the court to discharge jurisdiction because there really isn't any. Thank you.
And Mr. Dorda, I will give you a couple of extra minutes since we helped your co-counsel exhaust some of your time there.
Gonzalo Dorta on behalf of the name insured Gildo Menendez. Let me start off with I think that the rule, you have to look at the entire policy.
Actually, just how is the named insured impacted by this decision?
Well, the name insured is impacted by this decision because one of the passengers was in the hospital incurring over $275,000 of medical bills, semi-comatose, and consequently filed this claim to get it covered. The policy had a limit of $50,000. We asked for the tender. They said, no, go ahead and sue us. And then they subsequently filed a deck action on this matter, leaving $275,000 of unpaid medical bills. I think the issue in this case is very important. Here's the issue in this case, I believe. First of all, we started with a situation that we're interpreting an exclusionary rule. Hence, we have to go ahead and restrictively analyze it. Thus, if there's two equally plausible interpretations in this matter, I submit to you all that since we're talking about exclusionary rules, you should go ahead and pick that plausible one that is more restrictive, because we're talking about an exclusionary rule, not a granting of coverage. Number two, I understand that Cochran could have been wrongly decided, and I understand that maybe Missouri could have been rightly decided, and I understand that the dissent in Cochran, which says and admits that our analysis is equally plausible and reasonable, could not carry that much weight. But I suggest to you all that if you have judges sitting on the fourth, dissents on certain decision, a Missouri court, and you have the Cochran court, that should tell you that my interpretation is just as reasonable as his interpretation.
But now the Cochran court, that's back, in a 74 time period?
Yes, it was.
And at that time, insurance companies were not using the you and your for insureds back at that time.
No, I believe that Your Honor is correct.
So I think that added to some of the issues. So I'm not sure that Cochran is really on point here when you've got the new modern English that insurance companies have gone to.
I respectfully disagree, Justice Lewis. Here's the reason why. Please note that both Reed and Linehan talk about the validity of these household exclusions. They had a public policy analysis. We're not a public policy analysis. That's why my co-counsel is right. This is not a conflict jurisdiction. This is an interpretive debate. Whether or not his interpretation is the only interpretation that an objective person looking at this would reach. And I submit to you all that it's not. And here's the reason why. Justice Parenti brought up the issue of how would you write it to make it clear, because their obligation is to make it clear. They're the drafters. Well,
I mean, that's not the case, though, that you do not evaluate any clause in an insurance contract on the basis of, well, how could you write it better? That's not the test.
No, it's right.
That's not the test.
It's not the test. Here's where I submit as a test, is if you have two plausible, reasonable interpretation of this language, it is by definition ambiguous. If you have two plausible, which means they have to carry the burden and say, as they do in their reply brief, that our interpretation is illogical and absurd. Because if we have two plausible ones, then it means it is ambiguous.
I'm still concerned that we may not have jurisdiction. I can see that argument starting to blossom a little bit. This policy describes the named insured, does it not, in terms of you and your? Isn't that under the definition section? Yes, it is.
And let me address that. That's a very important point. They have 5 categories of insureds.
Right.
Okay?
Five categories of
insureds.
Insureds.
5 categories.
Right.
Okay? Because there's a granting of coverage. That's why it's so ironic. They expand coverage, but then they use that expansive terminology to then give an expansive interpretation of an exclusionary policy. You can't have it both ways. That's why Cochran, I think, gives a good analysis of the matter. But in any event, if you look at that, if you have 5 categories of people, and then you put the, which of the 5 is the? Let me give you an example. It may be a bad example.
This is missing the point about the named insured.
Right.
And that is talking about the named insured. That's what I'm talking about.
Right.
And does this policy not use you and your to identify when it means named insured under coverage A, liability coverage?
Yes, but it also uses the word the insured to mean the name insured when it talks about duty to cooperate, financial responsibility.
Well, duty to insured, cooperate. That's whoever the insured is going to have to cooperate. Keep going.
Right.
That's not limited to named insureds. Anyone who seeks coverage under that policy will have to cooperate, or there's no coverage. So keep going.
It has the financial responsibility, the name insured. That has
the named insured.
The name insured. That's what I'm saying. I think I'm not getting across the point. Is that?
Well, no, you are. Keep going.
Okay. If you look at the entire policy, they use the name insured in various other sections of the policy that you can't sever. You have to read it as a whole.
Rather than you or your.
When they use in these other sections in the policy, page 21, 22.
Does it say the name insured or the insured?
The insured, which only refers to the named insured, because on the duty to cooperate,
that can't be it.
And
because
the financial
all insureds, the insured and insured, that you're not selling me on that point. So go to one of the others.
And the legal fees and costs about reimbursement.
Well, that's the same thing. That would be any insured who may have coverage under the policy. Go to the next one.
They have also the issue of the financial responsibility. They talked about the insured can only be the name insured. And what I'm saying is that
I can agree with you on that one.
You do not necessarily, in this policy, conclude that the insured is not always the name insured.
But that's true, but I'm still, and again, I'm sort of wondering about this conflict issue myself, but Justice Kennedy giving you that we still have to before we look at the whole policy, got to see if by reading just this provision, we can understand who's excluded. And you would agree with that. And so if we look at it and say there's only one logical reading, that ends the story. We don't go look at everything else.
I agree, but if you look at the policy and you have to look at it as a whole, and the insured in other aspects of the policy that are not severable, they're not severable. I understand your argument that if they're severable,
I have no argument. I'm just trying to understand.
I understand the analysis, okay? But you have to look at the policy. There's sections of the policy that use the insured that only means the name insured, then there is a problem here. And the other thing that's very important, and I'll stop, is that on page 21, they use, and they know when to use it, they use the word such insured.
What coverage is that under?
That's
not coverage A.
That's
you're mixing coverages. What are the definitions for Section A, coverage A, liability coverage here?
They have the 5 categories of individuals.
Tell me what they are, please.
It's you means the name insured.
You or your, isn't it?
Right. The name insured.
And what else?
No, I don't have it.
Well, that's right. Don't use up all your time to.
Yeah.
I'll pull out the.
So basically,
if you could sum up now about.
I was 2 seconds. In conclusion, the cases they cite to give this honorable court, this high court jurisdiction, It's not what they're arguing now. This court, most respectfully, should not get involved in interpretive analysis of a policy. This court has jurisdiction on conflict. The conflict is public policy. We never argued public policy. And obviously, other courts and other jurists have found our interpretation to be as reasonable as their interpretation when you're looking at and the. Thank you for your time.
Thank you.
I have a question. In arguing to the 3rd District, did State Farm argue that Reed and Linehan compelled a different result?
Yes.
Because it's not mentioned in the 3rd District opinion.
Reed is mentioned in a footnote in the 3rd District opinion, and the court understood Reed to not address the direct application of facts. Linehan was argued in the 3rd District briefs. It wasn't cited in the court's opinion. If I could address a couple of...
Could you address the conflict issue?
Oh,
it sort
absolutely.
of goes back to this issue that when we are deciding that household exclusions are valid, that's not discussing whether a particular provision is ambiguous or not.
No, but I think both Reed and Linehan did more than address the abstract validity. Now, first of all, the fact that neither one says specifically it's an unambiguous exclusion, I don't think matters. What it means is the court was simply applying it as it's written, and I think both courts involved an application. Reed did so specifically. If I could read the court from the Reed decision.
Yeah, it's just that usually when we're finding conflict, you know, we since the conflict jurisdiction is narrow as misapplication maybe if it's a Supreme Court case, if it wasn't the issue before the court, it seems that it's and I haven't looked at the briefs if you've looked at in those cases to see if ambiguity was briefed, but that if it wasn't the issue before the court or a necessarily decided predicate, I don't understand how there can be conflict.
Well, it's true that neither decision says it's ambiguous or it's not ambiguous, but I think both, and Reed explicitly did say that it applies. I think implicit in that is the notion that, given the facts, it applies, which is exactly what the 3rd DCA, the point is this, any trial court in this state couldn't apply both Reed, Linehan, and also the 3rd District decision here. It would have to choose. The fact that the court didn't specifically say it's unambiguous, but went on to say it applies, I think is sufficient. And again, though...
so you're saying that the argument in the 3rd District is there's nothing to discuss. There can't be any ambiguity because you are bound to apply Reed and Linehan, and the court said, no, we read those decisions and we don't think it decided those issues. We don't see the conflict.
Well...
And that's not determined, of course, but it's just,
right.
it concerns me, and Webb wasn't, do you agree that Webb was not added until your reply brief?
Webb was not added until my reply brief. Now, let me tell you, I don't think I've gone afield of the issues as framed. I've cited a case or two further in support of the arguments we've made from the beginning, but certainly I've not gone afield. Webb, you know, it was appropriately cited, I think, in my reply brief. I think the court can, and I would respectfully submit should, consider it, because we now do have conflict with the Webb decision, if not Reed and Linehan, and I think we do have conflict with those cases. As far as the notion that Reed, again, Reed didn't explicitly address ambiguity, but it did explicitly say the policy applied, which is what the 3rd DCA wouldn't do here. I do have to address the notion that, you know, there may be out-of-state cases that applied this. I don't know.
Well, don't you, can I ask, you know, in fairness, you didn't raise the out-of-state cases until your reply brief. And they're representing that in the Missouri case, and I'm pretty sure, I mean, the Pennsylvania Supreme Court ruled differently. And if you're going to give us out-of-state cases and pick and choose, it seems to me that you ought to know that if in the Missouri case that the Pennsylvania Supreme Court ruled differently, and bring that to our attention. Don't you think that's what a lawyer should be doing, arguing in front of this court?
Well, you know, if Your Honor thinks I should have cited an additional case.
I'm asking you, is it in that Corcoran decision or not?
The dissent cites some out-of-state cases. I don't recall them involving the exact policy language. If they did, you know, it's possible they did. I don't know. And I apologize if I should have cited a contrary out-of-state decision. I've only cited the one Missouri case because it applied the analysis that we were advocating. And again, I can't promise the court there is or isn't cases applying this exact policy language.
Well, and the
other
fact
way.
is, that's not controlling law. It
is not.
I mean, if my recollection is correct, your ethical obligation is to inform us of controlling law.
Well,
And-
yes.
And there's no suggestion that any of these out-of-state cases are controlling law.
Well, no, and I've never taken the position that the Missouri case is controlling. I think it sets forth a good analysis. And certainly if I had cases in Florida that were controlling, I would have cited them to the court, and I have not found any.
I'm not suggesting a breach of any ethics. I'm just saying, at least from my point of view, if out-of-state cases are going to come in and they're not controlling, that when an out-of-state search is done, that we get no opportunity she has to reply to your reply. If it was in your initial brief, I can see it, but if you're now going to add something on, but I don't want to use up your time on it. I'm not suggesting you were unethical in this.
Well, I appreciate that. But as far as counsel's opportunity to respond, Ms. Ross isn't shy in terms of filing supplemental authority. The reply brief was filed 5 or 6 months ago. And again, if it should have been cited in the initial brief, then I apologize for that.
Let me ask you this question. In the Linehan case, is it sufficiently similar so that we have conflict? Because there it recites the facts and it gives a paraphrase description of the exclusion, but it does not discuss ambiguities or anything else like that. Is that sufficiently similar to give us jurisdiction?
Well, I think so, and for the same reasons I think Reed gives you jurisdiction. Neither case said explicitly it's...
Well, I think Reed's in a different category, I would suggest to you, because that's one bringing in the no-fault law and that kind of thing. But Linehan does have the very similar facts.
Right, and it didn't explicitly say it's ambiguous or unambiguous. It gave us a set of facts that I think are analogous to ours.
Right.
It paraphrased an exclusion, and we have to trust that the paraphrase represents a correct substantive description of the policy language. And again, it's analogous to ours in terms of referring to a family member of any insured residing in the household of the insured. So we have that same construct.
They say any twice, I think.
No, well, as my notes say, what it says
Any
is
insured or any member of the family of any insured.
residing in the same household as the insured.
As the insured, right.
Right.
Yeah.
So I think in relevant part is substantively the same as ours. And yes, it's true, Linehan is couched in terms of validity of the exclusion, but again, given that Reed had addressed the validity just a couple of years earlier, I think there's at least an implicit application going on here when the court gives us all the facts, gives us the substance of the exclusion, and affirms a summary judgment based on the exclusion applying.
So you're saying these two cases cannot stand, that if these two come before a court, it's one or the other, and so therefore both cannot stand.
I think that's true.
Okay.
And again, although yes, it's true, I only cited Reed in the reply brief. Again, I think it's a case that can be considered by the court for jurisdictional grounds.
Webb.
I'm sorry, Webb. For jurisdictional and merits issues. Let me see. Oh, as far as to address the real question, though, whether their reading is a reasonable one, I would just leave the court with this. I don't think it's a reasonable interpretation of any document to strip it of its definition and say, even though the definition of insured includes permissive insureds and named insureds, it's reasonable to say it's only going to apply to named insureds.
Do you have handy there the definitional section of coverage A? Tell us, read to the court what the definitions are in coverage A.
Of an insured?
No, just for insure, whatever it is there. It's got to be one little section, and it's got the one that says named insured, you and your, those things.
Coverage A, that's the liability coverage dealing with the covered vehicle, says when we refer to your car, et cetera, insured means 1, you, so that would be the named insured, 2, your spouse, 3, the relatives of the first person named in the declarations, 4, any other person while using such car if its use is within the scope and consent of you or your spouse.
Okay, so that makes the driver here insured. What else? Anything else?
Yes, a fifth one. Any other person or organization liable for the use of such car by one of the above. So someone vicariously liable for one of the above 4. That's it. That's the 5.
Those are the ones. Okay.
Yes. So you can see clearly we have 1 and 2 deal with the named insured and the named insured spouse. Category 4 is the permissive driver. And again, I would think it's not a reasonable interpretation to say, even though insured means these 5 people, we're only going to say that it includes category 1. I think the court has a basis for jurisdiction. And we would ask that the court, if there's no other questions, disapprove of the third DCA and remand for entry of judgment in State Farm's favor. Thank you.
Thank you. We thank both sides for your argument. The fourth and final case on today's docket is Kimrock Corporation versus Tampa Electric Company.
Good morning. May it please the court, my name is Jamie Adgraph and I represent Camra Corporation in this matter. The sole issue in this case is how to interpret Florida Rule of Civil Procedure 1.420E. Because this is a certified conflict issue involving a pure question of law, I submit that this case should be subject to de novo review.
I want to just ask you about the underlying facts in the case, the procedural history. Because my understanding was always that this particular rule was meant to control cases, to make sure they got set for trial in a timely manner. But then when when a litigant asked for it to be set for trial, then it's really in the court's hands to set the case for trial. In this case, the case was originally set in 2003, and it was continued in 2003. And was it continued at your request?
No, Your Honor. It was actually continued at the request of...
At the request of the TICO?
Yes, and my excuse me, my client did agree to it.
But it was they requested, they said that there was more discovery outstanding?
That's correct.
Okay. And then it says, again, was there another request for a trial date in 2005?
Yes, Your Honor. The previous counsel for my client wrote a letter to Judge Fryfield requesting a trial date in 2005.
I mean, there is a way under the rules that you say that the case is at issue and ready to be set. Was that done in this case?
Your Honor, what happened was we did ask for a trial date in 2003. Then there was the continuance. There was some additional discovery. In 2005, we wrote to the judge asking for a trial date. There were still some outstanding discovery issues with regard to, we were trying to get an expert report from the other side that they were not providing. I know the other side is going to argue that they were trying to depose some Kimrock employees. We were going back and forth trying to get dates for depositions and things like that.
And then, okay, so 2005 occurs, then 3 years or 2 years go on, and was discovery ongoing in that period of time?
There was, I believe there was a pending discovery motion we had made.
I guess what I'm trying to say, and then you get to this hearing, the grace period hearing, and you filed your pleading, and you again ask that the action be set for trial.
That's correct.
There's no recording of this. I'm just trying to understand why this case just didn't get set for trial. I mean, and this is helpful to you, I don't understand how this rule is even being invoked when somebody is saying, a plaintiff is saying, we're ready for trial, we want to go to trial.
And neither do we, Your Honor. When the continuance was granted in 2003, the order was open-ended. That judge, for some unknown reason to Kimrock, never set the case for trial. It was supposed to be, the docket was supposed to be reviewed, and at some point, I submit to you, the trial judge should have set it for trial. And then again...
You don't have any obligation to do anything beyond, this wasn't an answer to the motion, the thing about dismissal, correct? They were saying that the 10 months had passed and there was no activity.
Correct.
And then in your response to that, you indicate that there was some discovery that was going on, and you say this should be set for trial. But beyond that, you don't have any obligation to, make a motion to set it for trial, or call the judge's office and ask for a trial date, because quite frankly, I guess I'm a little bit concerned, because even at that point, it seems to me another couple of years go by before we, get to the second motion about dismissal. So
I understand your concern, and what I would say is, yes, we probably could have done more to move the case forward. However, by no means did we abandon our case. We did ask for a trial date several times. We were still talking to the other side, and I think that although there should be responsibility on the part of the litigants to move the case forward, I submit that there should be some responsibility on the part of the judge to order a case management hearing or set the case for trial. And for some reason, there were a couple of judges.
But the trial judge can't manage the case on behalf of the plaintiff. I mean, it's incumbent upon the plaintiff to monitor what's going on, and it doesn't seem to me that difficult to really calendar within a year to file something to advance the case.
And, Your Honor, I think really the issue is we could have done more, but we did not abandon the case, and we did file something according to the rule. We were following the rule that within the 60-day grace period, if you make a record filing, your case should not be dismissed.
Let me ask you, as you're on that topic for a second, I have the rule here in front of me, subsection E. How do you interpret that rule? Do you interpret it to mean that any filing will do, or does it have to be a filing that is going to move the case towards final resolution? Which way do you interpret the rule?
I'm glad you asked that, Your Honor. I interpret it according to its plain language. I believe that on its face, this rule speaks to this issue. It says, on the face of the record is one of the phrases in the actual rule, and it says, it really just says, no record activity occurs within the 60 days immediately following service.
Nowhere in the rule do the words move case towards final resolution appear. Am I correct?
That is correct, Your Honor. And I submit that this court's interpretation in Wilson v. Salomon should be applicable, where this court set forth a bright line rule, a bright line test, and said, either there's activity on the record or there isn't. We're going to take away any of the subjectiveness of this analysis.
Well, as you know, probably, the present rule came into existence in 2005. Before that, we had a prior rule where you didn't have the grace period. It was a one-year thing, and if there was no record activity during that time, then the motion to dismiss came into being. So the only difference that I'm seeing between the prior rule, the before 2005 rule, and the present rule is that the present rule added this grace period to it, like a 2-minute warning type of thing.
That, and also I believe the time was reduced from 12 months down to 10 months.
Well, 10 months, as if there's no record activity, and that's when you're going to get the notice, come and tell me something, and you better do something. It's what I call the 2-minute warning. It's telling you, you better do something or something bad's going to happen to your case.
Yes, Your Honor.
So, but we still have a 1 year if you
Yes.
had the 10 months and the 60-day grace period. So I did not see a change because Wilson was decided just a couple of months before we changed the rule in 2005. And Wilson, and I guess it's helpful to you, Wilson stood for the proposition that we have a bright line rule that you file anything, it gets you past the rule. We didn't change the language in the rule. So I would think that based on what the rule reads today, there's no need for any pleading to have any necessity to move the case forward to defeat the rule. Am I making sense?
I think I understand what you're saying.
Well, I think I understand. It's what worries me.
That's a favorable question.
I understand.
Okay.
I think that's right. Well, I think that could be right. I think that the 60-day provision is only under the newly amended rule. I think that it's clear on its face, and if you interpret it via Wilson, there's nothing that changes the definition of record activity in this rule. It doesn't say it has to be this kind of activity during the 60 days, that kind of activity. There's no specificity here. It just says record activity, which actually really does gel with the intent of the rule, and it really does gel with the intent behind Wilson, which is to have cases decided on their merits.
What was the pleading? What did you file? What did you tell the court by pleading in the 60-day period?
I filed what was called a motion in opposition to their motion to dismiss for lack of prosecution, and showing good cause why the action should remain pending. And the reason I did this is because I didn't want to just respond and say, no, don't dismiss it. I wanted to actually make a motion.
But where's the record activity then? If you're just saying a motion in opposition, how is that? I mean, that's not record activity. You're just responding to a motion. If you had said a deposition or said we still have to do this interrogatory, anything. But I'm trying to see, other than, that's why this may be the last part where you say you're requesting a trial date, and whether that's a request under Rule 1.430 to set the case for trial, because I think if you had filed a separate pleading that said Rule 1.430, that would have been not only record activity, but it would have moved the case along. But I'm trying to figure out how the trial judge is supposed to know. You sort of are saying, well, this is what has happened up until 2005, but I don't see the record activity, even under Wilson, unless you interpret the last wherefore clause. So where's your record activity?
The motion is on the record as a filing, and so that.
But in opposition to a motion to dismiss is not, even under Wilson, wouldn't be record activity. I mean, the contemplation was there'd be something filed that say whether you moved it along or not, interrogatories or a discovery deposition. I mean, you're just saying something about what happened, and the last thing that happened, according to this record, was in 2005. That's 2 years before the motion.
I understand, and as I said, Your Honor, perhaps we could have done more in the case. However,
well, you didn't do anything.
The case we did. We filed during the 60 days this motion. We have been ready for trial since 2003. We tried to get a trial date set.
So is it because you're from out of state that you don't know under the rules that all you got to do is file a Rule 1.430 demand for jury trial, and that goes to the clerk's office and the matter gets set?
Your Honor, I think essentially our motion was the equivalent of asking for a trial date.
You were ready in 2007, you're ready to go to trial?
Yes.
And we don't have a record. Are you representing as an officer of the court? You told the judge in that hearing that you were ready to go to trial?
In which hearing?
Did the judge just dismiss it, or was there a hearing where the judge decided whether it was going to get dismissed or not?
At the trial court level, yes. There was I guess you would call it a hearing, yes.
Well, again, we don't have a record. I'm asking you as an officer of the court, was it represented the case was ready for trial?
Yes, Your Honor, it was.
Is that the motion dated February the 24/7?
Yes, that's correct, Your Honor.
And number 12, plaintiff has been ready to proceed and remains ready. Was that what you're saying?
Yes, that is correct.
But that's sort of buried down into it. I mean, I guess.
And then in the wherefore clause, we asked, please set the case for trial.
And after 2 years when it wasn't, I mean, as time went on, I guess I'm really concerned that you feel like you can just sit back, you file this motion, and as a part of it at the end, you ask that the case be set for trial. But then months go by and nothing happens, and so nothing is incumbent upon the plaintiff at that point to say, Judge, I've asked for a jury trial, or whatever kind of trial it is you asked for, and nothing has been done. Can you give us a date? You seem to say that I can just sit back now from that point and do nothing.
I don't, if that's the impression I'm giving, that's not the impression I mean to convey. I don't say that it's our attitude that we can sit back and do nothing. We did do something.
You filed something, and maybe it wasn't done exactly the right way, but you did file something saying we want a trial.
That's correct, and that's exactly my point. And it according to the rule, that's what we need.
Florida decisions that say that if you file a notice for trial, that you do not have to do anything further by case law.
I'm sorry, I didn't hear the first part of what you said.
That if you file a notice for trial in Florida, you do not have an affirmative obligation to go further, even under our old case law. Are you aware of that?
Yes, Your Honor.
Well, why don't you argue it?
I mean, that's what I was saying at the beginning, and I don't know if you've argued it this way. I think, and I'll go back and look, that there is case law that says these rules for dismissal for lack of prosecution do not apply when a litigant has said they're ready for trial by filing a formal pleading. And you filed one back in 2003. So did you not argue that to the First District?
I believe I did, Your Honor. I did argue to the First District that we were ready for trial. That was part of my argument all along, and still is, that we're ready for trial.
So then the issue about what's record activity really becomes somewhat moot if this case was ready for trial and had been requested to be set for trial.
Well, I don't know if it's moot or not, because this motion is before the court. This motion to dismiss for lack of...
I mean, it can be decided on a basis, it's definitely live for you, it can be decided on a basis that this case was ready for trial and you indicated it was. Now, I agree, as counsel that really wants to go to trial, you expect there to be, gee, it's another year, 2 years, you sort of wonder what's happening, but that's another issue.
I guess what concerns me, and I guess what's concerning a lot of us, is typically what happens is as soon as the case is at issue, somebody files an answer. As soon as the plaintiff gets that answer, within the next day, there's a notice of trial filed. And if that lawyer doesn't get a trial date within a month or so, they're before that judge. What's happening? How come I don't have my trial date? And it seems here, you kind of just sneaked in the wherefore clause, by the way, we want a trial. And then just let it sit there. And you filed this case.
I have asked for a trial a couple of different times.
There were other hearings after that where you asked for a trial?
I asked in 2003. That is in the record. I asked in 2005 via letter.
Was that after the continuance was granted, you asked for a trial? In 2003, you asked for a trial. There was a continuance at some point in 2003 also, correct?
That's correct.
So was there another request for trial after the continuance?
There was another request for trial in 2005 where we wrote a letter to the judge.
All right, you're now down to 2.5 minutes of your total time, so you're well into your rebuttal.
I would like to then reserve the rest of my time for rebuttal. Thank you.
May it please the court. Pedro Bajo of Bajo, Cuva, Cohen, Turkel for Tampa Electric Company.
Let me ask you, if record activity within the 60-day grace period, if that means the same as the record activity in the prior 10 months under Wilson, is the pleading filed by your opponent sufficient to constitute record activity?
If Wilson were to apply, where it says any piece of paper that goes into a court file is record activity, yes. But
Okay.
that seems to fly in the face of the amendment to the rule.
Well, it doesn't. The amendment to the rule is exactly what the court did, was push back so you could do it in 10 months rather than 2 years, than at a year, and give people notice because it was coming up on the year, and there's not a change in the language at all. Why would we resolve all the uncertainty and all the subjectivity in 1 month, and then the next month put all that subjectivity back into the rule?
Well, in the committee notes to the rule, Your
Committee
Honor,
doesn't pass the rule. This court passes the rule.
understood, but even in Wilson, in footnote 1, this court said that there should be deference and consideration, at least given to the committee notes, in order to address the purpose behind the rule.
Well, but
and I know it's not part
in
of
the
the
reality
opinion.
that when we pass a rule, we should say what we mean, and then we should follow what we have said in the rule. And it seems to me that, you know, you look at this rule, the text of the rule, and what you would conclude from that is, if you look at the earlier version and the new version, you conclude, well, they have done something here to help avoid a trap for the unwary and to give people a chance to get a warning and then come in and do something. But the something that they would need to do would be pretty minimal under the rule. And let me, before I give you the chance to answer, say, I'm not sure the way the rule is set up is a very good idea. I think it allows these things to kind of languish and sit there and sit there and sit there. And maybe what we do need is a different sort of rule that would allow factual judgments to be made about whether things are actually happening to cause the case to progress. But we don't have a rule like that. And we made very clear in Wilson that we don't have a rule like that. And it seems to me that if we're going to have a system that is consistent with the rule of law, we ought to follow what we have said.
And
now, why am I wrong?
Well, I think the committee notes are instructive in that regard. What the committee notes say is that the rule was amended in order to provide notice, and I don't disagree that providing notice is a good idea. And the provision of notice being in order to enable the party to recommence prosecution of the action.
And I guess now going to that, the way I envision this rule, first of all, the old rule was definitely a gotcha. And then we were saying, well, any pleading is going to suffice. But this idea of this 60 days, in my view, and I guess I don't know if anyone joined in my concurrence, but I wrote a concurrence in, I guess, Wilson, is that at that point, in that 60 days after something is filed, the trial court has a stat hearing and figures out, is this going to be tried in the next millennium or in the next year? And so for the life of me, I don't understand if somebody is saying, I wanted to go to trial in 2003, I wanted to go to trial in 2005, and now I want to go to trial in 2007, what would cause a trial judge to dismiss the case?
Well, Your Honor, what happened in this case,
I mean, that's, to me, again, and I want to just, it's that can you tell me if once somebody has filed a demand for a jury trial, they have then, whether it's right or wrong, it is up to the trial court to set, or the clerk with the trial court to set a date for trial. That's how Rule 1.430 works? Notice of trial, demand for jury trial?
Is it 1.430 or 1.440 that you're looking at?
Demand for jury trial.
There's only
I'm
one of them.
looking at four-
There's only one rule for demand for trial.
Yeah, 430, demand for jury
Okay.
trial.
The rule setting trial requires two things. It has to be at issue, and it has to be ready for trial. And there are cases that say that has to be strictly construed. Just because something is at issue does not necessarily mean that it can be set for trial.
Well, that's not in the context of the dismissal rule. in the context of the dismissal rule, Florida law very clearly says that if a claimant files that notice, I'm ready for trial, that the 1 year lack of prosecution does not run even if the trial's not set for 2 years. You agree with that?
I agree with it if it's not withdrawn, Your Honor.
Okay.
And what happened in
Okay.
this case was it was set for trial in 2003. And the motion for continuance was a joint motion. It was not a motion for continuance from People's Gas or Tampa Electric Company. It was on both parties' behalf. The trial court was trying to administer its docket. It set it for trial. Then the parties came in and said, we need more time. So the court enters an order and establishes the procedure to set this case for trial again. You've already messed up my docket. I'm going to require in my order a proper motion for trial to be filed.
Is that what it said?
Yes.
And so
The case can be reset upon any party filing a proper motion for trial.
Well, so what was their
Never
motion?
was done.
The motion that was filed during that 60-day period asked for a setting of the trial. So why doesn't that comply with what the trial judge required?
Because that's not a proper motion, set it for trial. Under the rule, when you have a proper motion to set it for trial, you need to identify whether it's a jury trial or a non-jury trial, whether the established time for trial.
Isn't the real question is whether it's record activity?
Well,
I mean, forgive me, it may be inept record activity, but if it's record activity, it's record activity.
Okay, and I think that, you see, there's two steps here. We filed a notice of intent to dismiss for failure to prosecute, triggering the 60 days. Within those 60 days, they file their motion in opposition. It's an opposition, but it says motion and to establish good cause. We didn't file a motion to dismiss at that point. They filed something in those 60 days after we gave them notice. 16 more months go by. Nothing. It has to be
in that filing, did they ask in both the pleading and in the wherefore clause, set it for trial?
I believe it was in the wherefore clause.
Okay. So then that may come down to, all right, but then it may come down, your position is that's not a technical compliance with Rule 1.3 whatever, 1.4 whatever.
And it's not in compliance with the procedure established by the judge and the cases.
In Section E, the rule, the failure to prosecute.
Yes.
Rule, the words no record activity appear 3 times. Nowhere in the rule does it say move case towards final resolution. So where do you get that from?
I get it from the committee notes, and as well, the language of the rule is somewhat inconsistent if you try to apply Wilson to it, because the language of the rule says, it talks about getting an order for a stay. Well, if all you need is any piece of paper whatsoever, then filing a motion for stay is just as good as getting an order. But that's not what your rule says.
The rule says
you have to actually have it.
Excuses the time if you have a proper motion to stay. What's unclear about that?
No, it doesn't say if you have a proper motion to stay.
You file the motion for stay.
No, it says if a stay is entered.
Well,
I mean, the motion itself is not self-executing. You have to have it entered. Or it says if good cause is shown. Well, there's no reason to have a hearing and establish good cause if all you have to do is file a motion that says it. The rule itself indicates further steps. And if this, I mean, what this court needs to decide is what the effect of this rule is going to be. In the state of Florida, I think there's a lot of people looking to see, is this rule going to have any effect on advancing cases on the docket, or is it just going to bring everything to a screeching halt?
Are we going to return to the days we're going to fight more over pleadings than we do getting cases moving? to the old days, which was based upon a statute. Statute was removed. There came out of the rule, moving it towards trial. Now you want to go back. I think your better argument is that what they filed was not what was contemplated by the rule, rather than something else.
Well, Your Honor, I think that the old rule is actually more effective than the current rule if you're going to require any piece of paper whatsoever. I don't think it's a bad idea to give people 60 days notice to recommence, as it says in the note. But to file anything
on this posture, okay, because you alerted me to something and now I'm looking back. So you filed your motion to dismiss for lack of prosecution. In 60 days, there's this motion in opposition that's filed in February of 2007. So you don't do anything more. Nothing more is done on this case from February of 2007 until 16 months later, you filed a motion to dismiss?
Yes, Your Honor.
So why isn't the argument, did that then start triggering another 10-month with a 60-day window? What was the basis of your motion to dismiss?
And that was the argument that we made was, and the rule says, upon a period of inactivity for 10 months. And if we're going to be talking about strict compliance of language of the rule, it doesn't say each and every period of inactivity of 10 months. It says a period of inactivity. We filed a notice originally, not the motion.
Okay, so the motion in June, did it then give them another 60 days?
In my position, no, it didn't, Your Honor.
Because you're saying that whatever had happened a year and a half before that you didn't bring to the judge's attention was enough to cause the dismissal of this case?
Oh, it was in our pleading. It was in our filing.
No, but what I'm asking you is why, if you didn't think what they filed in February of 2007 was sufficient, because again, both parties have some obligations here. I mean, you don't want this case to be pending against Tico. Why didn't you then, when you saw that this said nothing, is what you're saying, it did nothing to recommence prosecution, it was a nothing, then ask the court in 2007 to dismiss the case?
Why did we ask them to dismiss the case?
Why didn't you?
We did, in 2007, because it was paper in the file, Your Honor.
You see, the way there is a problem here, because my understanding was to be that there's that 10 months. In the 2 months after, it's not just like another paper gets put in the file. The judge then, because it's now been brought to the judge's attention, gets the parties in front of the judge, says, what's this paper? What are you doing? It's either sufficient to dismiss the case because there's nothing, or nothing was filed. If nothing's filed, then the case gets dismissed. Certainly, that would have been your argument of nothing, so it's case management's off. Or let me see, is discovery still pending? Oh, you want to set it for trial? Do you agree, Takeo, it should be set for trial? Set it for trial. Not the idea that then the other side who wanted it dismissed will wait another 16 months and do nothing, and then all of a sudden, 16 months later, file a motion to dismiss. I'm concerned about that, and I'll look at the pleadings, why you would have waited another 16 months to get the judge to dismiss this case.
Your Honor, the case didn't move. Well, nothing happened, and the only way to get...
Do you think that then it was inept? Because if the wherefore clause had been a notice under a demand for jury trial under Rule 1.430, would there have to have been anything else in the next 16 months to be legally ready for trial?
To be legally ready for trial? I mean, they would have to have it heard by the court and have an order entered. The issue is...
A notice under Rule 1.430 requires that it be called up for hearing before the judge?
I think we may be referring to two different rules. I'm referring to 1.440B and C on setting a case for trial.
Notice for trial, okay, and I'm looking at demand for trial. I am looking at the, so when I've been saying 1.430, I apologize. We're talking about Rule 1.440, the notice for trial.
Yes.
Is there, in that, it says actually that the clerk shall submit the notice in the case file to the court.
Mm-hmm.
So this wouldn't have been legally sufficient because this wouldn't have alerted the clerk to let the judge know.
That's accurate, and in subsection C, the court has to have the hearing to determine that it is ready for trial, and the cases interpreting that rule say that. And the problem is you already had a case set for trial. It was continued at the request of the parties. The judge set the established procedure. And at that point...
Does C say that the judge has to hold a hearing on setting it for trial?
Well, he has to make a determination that it is ready for trial. It doesn't necessarily mean a hearing, but the issues that required the joint motion to be filed in the first place remain today. So if the case wasn't ready for trial when the parties filed a joint motion, how is it ready for trial today? They have kept saying that they were done with discovery, yet they make comments about not being able to take Tico's expert witness deposition. How can you be done with discovery if you're yelling about taking somebody's expert deposition?
Since
it's
they
inconsistent.
filed their pleading, their motion in opposition, there has been nothing else filed by them in the trial court.
Absolutely not. Since they filed the motion in opposition, 16 months went by before we filed a motion to dismiss.
Was anything
and
going on?
at that point, we thought the case had been abandoned.
Was anything going on behind the scenes during that 16 months? Were you still doing discovery? Had whatever problems been resolved or trying to resolve them?
Ms. Adgraph will be able to speak to that better than I because one of my colleagues was handling the case out of Jacksonville. She's indicated that she left telephone messages for her, I believe, a couple of times to discuss some things.
I am still confused on this issue, which is that were you seeking to dismiss the case based on the motion to dismiss that was filed in 2007, with the response being the February 2007 letter, or pleading, or were you seeking, when you filed the motion to dismiss in June of 2008, to say that there had been 16 months, where now from the time of this pleading in 2007, that nothing had happened?
Okay. What we said was we filed a notice under the rule, not a motion, a notice that gave them 60 days, told them, you know, what it says you need to do within the 60 days. They filed their opposition.
And then you waited, and then 16
and then nothing.
months.
We didn't file a motion.
Okay, so 16 months goes
16
by.
months of no activity. And we file a motion to dismiss.
Based on whether the pleading in 2007 was adequate.
It was two-pronged, and now we're getting to where I think we have, there are two real issues here to decide. You know, number one, what happened with that original time period, but then additionally, you have another 16 months. So you have two time periods, significant time periods of inactivity. The cases that have all been cited to the court by everyone and that are applying Wilson, they don't really address this kind of factual scenario.
But they
what
do.
do you do?
But they do. In other words, I thought we've had cases. We had so many of these cases over the years. I can't believe we have it's back again. But where if there had been a year somewhere 2 or 3 years before where nothing had happened, and then things start happening, and then nothing happens, and then something starts happening, you can't go back and say, well, because in that year nothing was happening, that is insufficient. I think what I'm concerned about is I thought the rule would operate where once that 10-month and then the 60-day grace period would be there, the judge would, on the party's request, set this for a hearing to decide is it or isn't ready. I didn't think there'd be a whole other 16 months, or I think you'd have to then, because you didn't try to get resolution on the prior one, would have to give them another 60-day grace period.
And that is an issue that this court needs to decide, and that we made as part of our motion, and we briefed to the first DCA. You will end up, and where I was trying to say to Justice Lewis, the old rule is better than the new one if you're going to go ahead and apply something like Wilson, because every time that there's 10 months of inactivity, you send your notice, you get an interrogatory. Then somebody sits back and does nothing. Then there's 10 months of more inactivity. I send a notice, I get a request for production.
Well, couldn't have that happened under the rule that existed as it was interpreted by Wilson?
I wouldn't have had to send a notice if they didn't do anything for 12 months.
But I mean, essentially,
this,
this just activity that is record activity,
right,
but which does not really move the case forward, could still happen. And you could have this series of instances like that.
The idea behind the rule is a good one. Provide notice in 60 days.
Well,
it has to be to recommence prosecution to make any sense and be effective.
In June of 2008 is when you filed your motion to dismiss?
Yes, Your Honor.
Assuming that was a notice to dismiss or whatever the rule requires, when did they file anything after that point? Was it within the 60-day window? Because I know it was sometime in August, but I'm not exactly sure what is the date. So was what they filed after your second filing within a 60-day window?
I believe that it was, I don't have the exact date, but it was more than 5 days before the hearing. And I do believe that was within the 60 days. And then they filed an affidavit that
But really, the
basically
first
said
district was looking at that first period, were they not? As you read the opinion, that's what they were looking at. This is a separate argument from what the first district, how they approached the case.
Well, it's a tipsy coachman type of argument.
Okay, all right. So they did not go down that path.
The first did not go down that path. But I think that they did try to reconcile the rule and give it some meaning to effectively manage and allow trial court judges to manage their dockets. As it stands, it's a lot more difficult for them to do it with this new rule if any piece of paper whatsoever is going to apply.
Except if they had if you called it up for a hearing back in 2007 and they said we wanted to go to trial, the judge would say, is it ready for trial? Wouldn't that be the way we would hope that this would work? Not another 16 months on the judge's docket?
Yes, that's exactly right, Your Honor. But after you have another 16 months of no activity, we go from a period of 13 months of no activity, we get a piece of paper. Then there's 16 months of no activity. I mean, these rules also need to apply for the benefit of defendants as well. I mean, they are stuck in a case that the cause of action, essentially, according to their pleading, started in 2000. The initial complaint was filed in 2002.
So notice it for trial.
I sit here in 2011. I mean, sure, Your Honor, I could notice it for trial, but that costs my client money to go through all of that.
Well, your complaint is not set for trial. I mean, you can set it for trial just as well as the other side.
You're right, Your Honor, but why would I set a case for trial that on the face of the record and what it looks like to everyone else has been abandoned? They haven't done anything for 3 or 4 years.
So you show up on the morning of trial, they're not ready, and the judge enters a judgment in your favor. I mean, this is becoming a game again. You know, this is becoming a game again, and that's exactly what this rule and what Wilson was designed to stop. And so you can set these cases for trial.
Well, Your Honor, I can tell you that I think that the rule, if it were applied to recommence prosecution, makes a lot of sense, and I think that the notice makes a lot of sense. And it gives people warning, and it's not a gotcha game anymore, but it can't be a continual notice every single time. You basically get your one notice, you've been warned, don't let it happen again.
Where does the rule say that?
It doesn't say that, Your Honor.
So
that's what I'm saying. That's what this court
then
needs to make a determination.
Right. All right, you used your time. Thank you.
My client followed the rule to the letter.
I really, this isn't a sympathetic situation to me. many of us who did plaintiff's work, if someone wants to get to trial, you don't wait for 7 years and just keep on going, well, I wrote a letter to the judge, I wonder why it's not set for trial. I mean, this is in Jacksonville, the Fourth Circuit, a busy circuit. There's a rule, and I kept on saying it was 1.430, but it's 1.440. It says what you do, how you file a notice for trial. And so I don't find this to be your client's been chomping at the bit to go to trial and just has been thwarted by Chico just trying to use everything they can to prevent you from going to trial.
But, Your Honor, if this case gets dismissed, this is basically a surprise dismissal. And we're going to be deprived of our rights to due process and of our case being heard on the merits because we made a record filing in 60 days, and that's what the rule says.
You think that after, okay, you filed that, we would like it to go to trial in 2007. Now, months and months go by, you think, well, it's still on the docket, but don't you think you're going, well, gee, when's it going to be set for trial? I mean, file something to call the court, say, why isn't it set for trial? I mean, anything of that nature?
I did ask for it to go to trial, and I did ask for it in my motion, both in the substance and in the wherefore clause.
But do you think you know under Florida rules that would not be sufficient to alert the judge? It's filed in the court file. The clerk doesn't know unless it's filed under Rule 1.440 that it's ready for trial.
And to your point, under Rule 1.440, the judge could have set the case for trial and probably should have at some point.
If it was a proper notice under that, how could you think that the judge is going to take this pleading if no one calls this up for a motion, if they didn't call it up or you didn't call it up, and ask the judge, you know how to get a motion heard, and ask the judge to set it for trial. The judge isn't going to know unless the clerk sends it up, and the clerk's not going to send it up unless it's under Rule 1.440.
Your Honor.
Are you beyond the statute of limitations in your case at this juncture? Because if it be dismissed, it'd be without prejudice. But it'd be with extreme prejudice if you're beyond the statute.
I believe that I am, Your Honor. It's got to be. It's got to be.
Are you still ready? Are you ready? And is your client ready to go to trial?
Yes, my client is ready to go to trial. And Your Honor, you said so yourself in your concurring opinion in Wilson, that although most of the responsibility is on the parties to move the case forward, that the trial judge has some responsibility to make sure the cases don't languish on their dockets. And my answer is that there is a safeguard here, which is either the parties can ask for a case management or the judge can order case management or set the case for trial, and that didn't happen here.
Did you ask for one? I mean, this is your case. It's not the judge's case.
I understand that, and I did say that most of the burden is on the litigants, and as I said, I did ask for a trial in my motion. I did ask for a trial in a letter.
But the problem is the motion wasn't called up. Was it called up?
What do you mean called up?
Did the judge hear the motion?
Yes.
We're talking about back in 2007, when he filed his notice, you filed your motion, there was a hearing?
I think, do you mean when it was in front of the court in Duval County? I'm not sure.
When it was before the court on their motion that was filed in December of 2006 that said there have been no record activity for 10 months. You then filed your motion. Was there any kind of hearing on his notice and your motion?
There was, yes, there was.
But not till 2008, after another 16 months had gone by.
After another motion. But I'm talking about in 2007, was there any kind of hearing before the judge to discuss why there had been no record activity for that 10-month period?
We had oral argument with the judge. I participated via phone, actually.
Was that 2007 or 2008?
I am not positive. I believe it was 2007.
Well, then the judge didn't dismiss the case in 2007? Was there an order entered? We'll see whatever's in the records in the record. So, and your affidavit will speak for itself. But what I'm understanding is that nothing happened until they filed something again in 2008. You're out of your time.
Thank you.
All right, we thank you. Court is now adjourned.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.